না না কেউ করবে না, আমরাই মামলা করবো। তুই আছিস? তুই আছিস? আমি বললাম এই তো মোবাইলটা খুলে বসি, গিফট দিই। আমারই কিছু কথা দিয়ে দেবে। এটা তো আমাদের কেউ কিছু বলার নেই, আমাদের কিছু বলার কথা বলে না। ও কি দুটো তাই তো নিয়ম, আমরা রাজনীতি দুটোই আসছি। তো রিকমেন্ডেশন কোথায়? তো
রেকমেন্ডেশন কি করে হবে? ডিএগেশন ছেড়ে দিয়েছে, প্যানেল এক্সপায়ার করে গেছে। রেকমেন্ডেশন
কোথায়? রিকমেন্ডেশন কোন পাতায় আছে?
এখানে তো রেকমেন্ডেশন থাকবে না।
হ্যাঁ পিটিশনকে জায়গাতে তোরা সর কি রে না
Call the list.
Lordship,
এক নম্বর
Lordship, the original credential, Lordship, they are not supplying the concerned principal. Also, unable to get the certificate, and this is the last month, Lordship, unless this my application will be lapsed. This is a higher education, Lordship, dentist. I have completed the program in all compliance of all formalities.
Who is holding back your
Lordship,
documents?
the concerned college, dentist college, and my application for certificate pending before the DCI, Dentist Council of India,
All right.
Dental Council of India.
So what is to be done
So,
now?
Lordship, this unless the original credential is
Where is your matter?
Lordship, the item number 1863.
So you are mentioning for upgradation?
Lordship, this is the I have filed till Lordship. This has been listed in the monthly list 1863.
I have mentioned a date when upgradations will be taken up. Please mention on that date. Today is 17th and 20th matters will be taken for upgradation. Please mention on that day.
May I have your leave, Lordship, under compelling circumstances I mentioned this matter. Your Lordship heard this matter.
For
This is
what are
also
you mentioning?
a retention for documents of the Bardhaman Medical College, Your Lordship. Last
You
week,
want
Your Lordship-
upgradation?
No, upgradation, Your Lordship fixed the date on 27th, Your Lordship. The merit list already been out and my name is on the merit list. The document verification is on 24th, Your Lordship. This is the urgency. Eitherwise, I don't get back my original documents. I cannot participate in the verification process, Your
And
Lordship.
when was the order passed?
15th, on 15th, item 7, Your Lordship.
That day it was item 7, but day has already been fixed. In that case, to be mentioned on Monday, keep it. Yes, call the list.
My lord, before my learned friend starts, my lord, I beg to appear on behalf of the state of West Bengal. My lord, I am instructed that no copy has been served
in the new regime.
to the new regime, my lord.
No copy has been served is not right.
The new regime. To the new regime.
Copy has definitely been
Must
served.
have been. So that is why
You
I
may
said,
not have got it.
yes.
Right? Take soft copies. He has already served 2 copies.
My lord,
I'll
the
give you.
Sharthak original side is not available in
I'll
Sharthak.
give him a copy. My lord, the main allegation against the school authority. My lord, the lordships know, my lord, the
Is the school appearing?
yes.
No,
My lord, the
Then main allegation against
Asho Dhuko.
at the back. No response. No
I am very
space
afraid
for
of
Dhuko. Can I afraid them?
Mr. Bhattacharya will not get space.
Yes, you are there for the school. Gyan Bharati Vidyapit.
My lord, the lordships know,
What
my lord,
is
the
your
judgment
matter?
of Boishakhi Bhattacharya of the Honorable Supreme Court. As per paragraph 47, my lord, I was not found, my lord, not within the call of tainted candidate. My lord, I wants to, my lord, resume my previous school duty.
But then the time period possibly has expired long
I
back.
had applied. DI commissioner wrote a letter to the school repeatedly. School did not allow me.
Where are those
Yes,
documents?
those documents, your lordship, kindly see. First of all, your lordship will find page 51. 51 school has, my lord, reported to the DI Jalpaiguri because the present school, my lord, within the district of Jalpaiguri. Page 51, your lordship will find. Page 52, there is a list. My name is serial number 8.
Page 51.
51.
Banarhat, you were there.
Yes.
See, the 2016 SLST, you were appointed there, and prior to that, you were in
Prior to that, my lord, I was, my lord, my learners for schools, my approval,
Gyan
my
Bharati.
service was accorded, I am getting salary, DA,
All right.
everything. I mean, I have annexed also, my lord, my appointment letter approval.
All right.
etc.
Now what has
Now
happened?
after this letter,
Hmm.
also will find, my lord, the page 67.
Hmm.
This is the order of the Commissioner of School Education addressed to all districts. Next page, there is a list of the untented candidates, serial number 8, my name. This is the Commissioner of School Education.
Previous service as claimed is such and such. All right.
Again, my lord, page 69. Also, my lord, the wrote a letter. Last, my lord, the page 70. DI Kolkata also requested to the headmaster, my lord, the school authority to resume my duty. School
And
did-
you are serving in what post?
my lord, the
Assistant teacher?
Teacher, my approval.
You are Bhuvaneshwar Choube,
Yes, my lord,
assistant teacher. What is the subject? All right, let me understand from the school what the school has to say.
Well, Lordship, my lord, kindly turn to page 45. This is the order of this, my lord, in pursuance of the directions of this honorable court. My lord, the GI has approved my service in the subject geography.
Geography,
Yes. And my lord,
social science.
and also your lordship will find, my lord, 74. My lord, I was offered for appointment in upper primary school also. I did not, my lord, I have not accepted because after the that recommendation was made prior to the, my lord, after the judgment. That is why, my lord, as per paragraph 47, I want to.
What is the stand of the school?
My lord, this, first of all, this school is only a DA getting school. It is not, my lord, a totally fully aided government school, and the recommendation was never made by the commission at any point of time. This was a, internal selection by which this gentleman was selected at some point of time. This was not,
Internal selection.
my lord, the school's, my lord, own selection process, private school.
Yes.
My lord, it is governed by the special constitution. Now, my lord, it is not amenable, my lord, ordinarily to the, my lord,
With
recruitment
jurisdiction.
rules, my lord, recruitment rules, my lord, of 2016 or 2025. Now, my lord, the difficulty here is, my lord, we have extended it to the DI, my lord, that he had resigned on 26/8/2021 when the strength of the school was 549 strength. There were the present strength, according to our instructions, is 462. In classes 11 and 12, there are 12 periods per week. 9, 10, 12 periods, 6 to 8, 12 periods. The school already has 1 qualified geography teacher and 3 social science teachers who are adequately discharging the entire academic requirement. From the academic and administrative point of view, there is no additional requirement of any particular teacher. In any event, by our communication at page 71,
The advocate's communication.
we had indicated, this following thing, that, this is, he had unilaterally, resigned from the post, and he had accepted, whatever, we have the acceptance letters also, acceptance of all his terminal benefits, and, subject to correction by my lord, I may be incorrect, the Honorable Supreme Court did not interfere with these teachers, because admittedly, if he is untainted, he is permitted to continue in his, existing service, till a particular date. As per the Honorable Supreme Court's order, 31st July, as is standing today, whatever, 31st of July or August. So, in any event, there is no impediment insofar as him continuing. Now, first of all, the Honorable Supreme Court, perhaps, with greatest of respect, did not intend that a person who was working in an unaided private school, he is to get back if he opts to come back to his original service. My lord, it is essentially, my lord, there is no continuity. Kindly visualize that aspect also. He had unilaterally resigned, wanted to participate in the process, and thereafter participated, got through the selection, got an appointment. Admittedly, he is not any, my lord, he is not a tainted teacher. He is an untainted person. It is his misfortune that he lost his job because of the order, or likely to lose his job. Now, my lord, this is our, my lord, I leave it to the court. I am not taking, my lord, essentially the point regard. Of course, my lord, I should, but essentially, my lord, an order inter se the Gyan Bharati school, perhaps, my lord, is not, my lord, what can be warranted from your lordship's court. But, my lord, I am leaving it to your lordship. My lord, if your lordship wants, I can explain the entire stand by way of an affidavit. But we don't have a vacancy, that is one. And, my lord, we can't accommodate him, that is two. Apart from, my lord, the usual, my lord, this defense that we take, my lord, that it's not amenable to this jurisdiction.
What will be the stand of the commission?
Commission has, my lord, wrote a letter to the DI to commission, my lord, school service commissions has nothing to do. Because
Presently, School Service Commission has
as
no.
per the recruitment rules, my
But
lord,
prior
I
to
have
that,
annexed
if your
the
lordship
recruitment
kindly
rules.
turns to page 45(1). My lord, he was initially appointed as irregular and unapproved in the Gyan Bharati school. Subsequently, by adopting one resolution dated, my lord, memo dated, my lord, 1st of February 2020, 11, 45. My lord, District Inspector of School, my lord, approved his service as, and now thereafter he is getting DA from the government exchequer. So, my lord, ultimately, my lord, he is not directly, but otherwise he is.
That is, he is
Paid by the school.
Only DA portion has been paid by the government.
No, there is a recruitment rules. I have annexed
And
the
my lord,
recruitment rules. Following the recruitment rules, I was
and another
selected,
thing,
I was
lord,
appointed,
para
and I
47
did
of the
not, my lord,
Supreme Court
tender my
judgment.
resignation before, my lord, participation at the selection process.
And
After appointment, I, my lord, obtained
No,
leave.
no, I understand, but if the school where you were serving at that point of time doesn't have a vacancy, right? And the salary is being paid by the school directly, not by the government.
Salary, my lord, the DA,
Then what is to happen?
DA is being paid, my lord, by the
It
state.
is only the DA
And also,
component
my
that
lord,
is
the
being paid.
Supreme Court exactly, my lord, what is the page, paragraph
Almost body
47,
annoyed.
you will also kindly see. Paragraph 47. এটা দিয়ে দিই।
এটা কি দেখাচ্ছে?
ওই যে judgment.
It is not covered by paragraph.
Yes, paragraph 47. You will also kindly see.
Yes.
পড়ুন না, জজ সাহেব পড়ুন।
Some of the appointed candidates who do not fall within the category of tainted candidates may have the previously worked in the different departments of the state government or with autonomous body.
This is not a autonomous.
Yes,
body
this is
of
the
the
statutory body. School is recognized by the government.
Statutory body.
School is recognized by the government following the recruitment rules. Recruitment rules have been framed by the state government. And my lord, last paragraph, last line, you will also kindly see. In such cases, although their appointments are cancelled, these candidates will have the right to apply up to their previous department or autonomous body to continue in service with those entities. These applications must be processed by the respective government departments or body within 3 months, and the candidates will allow to resume their positions. Further, the period between the termination of their previous appointment and their rejoining will not be considered as a break in service. Their seniority and other entities entitlement will be preserved, and they will be eligible for increment. However, for the period they were employed under the disputed appointments, no wages will be paid by the state government or autonomous bodies. Further, if required, the necessary supernumerary post may be created for persons appointed in intergum. Well, this is the way, if required, well, all those appointments, the assistant teachers in geography were appointed prior to my after the joining, after the resignation from that schools. All were working from since long back. They cannot say that this post as might not be in excess post. And DI Kolkata again, my lord, this is the letter to the address to the schools, requested to resume his duty.
The board doesn't have any say over here.
Board SSC does not serve. Only my lord, the
The
school.
state can
State-
see whether and where the petitioner can be accommodated.
Kindly allow me to go through the petition and take the instruction and come back, my lord.
Because I remember in one matter,
Yes, yes.
there was an employee of the bank.
This is the
Uh,
bank.
Yes,
When in
Which
court room
went
number
up-
18. Well, my lord,
whatever.
that, my lord, that was a, my lord, subject to correction. That was not a private bank.
No,
It was, my lord, a
nationalized bank.
Nationalized Bank, my lord, Supreme Court has dismissed the SLP also.
Yes, that means the order passed by the
Court has
single
been-
judge has been
Yes.
affirmed, right? So if that be so, why can't the petitioner be accommodated? This is the first thing. And in case you say that you do not have a vacancy, there is a provision for creating supernumerary posts. And that about, if you say that you are only paying the DA component, in that case, why can't DI take any steps to accommodate
that
the
is, my lord, I do
petitioner
not have any.
in
I am not
any
standing in the way.
vacancy where
My lord, only this
he
much
or
you
she
lordship
can
will
be
permit me to
accommodated.
say this, my lord, kindly pardons me. My lord, these schools generate the funds, my lord, for payment of salaries. My lord, so, my lord, today an additional burden would be imposed in the event this person needs to be accommodated. First of all, and second is, my lord, we don't have the mechanism to employ him. Now, if
Mechanism means?
mechanism, my lord, we don't have the requisite number of students so as to, my lord, enable him to teach. My lord, there is a, my lord, staff pattern also. My lord, and supernumerary, my lord, I cannot create a supernumerary post.
Post is
The
sanctioned
post,
by the DA. DI.
the post has to be.
No, if there aren't enough students.
DI has sanctioned the post. They
No,
can
there
It
is-
see
was
how
at
many
that point of
students,
time.
teachers people ratio, how many.
It was at that point of time when you were there.
At present, how many students and how many teachers?
Let the
State can
DI, file a report. You have heard what the submission is. You go through the papers, find out what is the status of the school, how
And
many
I
students
will
are
also
there,
come back.
and how many vacant posts are there, and everything, and what will be your stand in case the student-teacher ratio is not matching. Then what is to be done? All right.
This will be an interesting question.
Why it didn't come up
No.
earlier?
No. This issue has now come, subject to correction. You know, this private, unaided DA getting school, getting back service, you know, this issue has never come, subject to correction. I mean, I don't think so.
How can it be private? Well, this managing committee is formed as per the management rules.
Please come.
Everything, recruitment rules is there.
Managing committee is formed as per management.
Yes.
The petitioner
Get-
was serving in the Gyan Bharati Vidyapith,
Yeah, আমি যাও, এখানে যাও।
a recognized DA getting school.
পরে আসছি তুমি।
Stop.
এই তো আইটা
এই শুনি।
আছে।
ফোন নাম্বারটা কিন্তু বলো তো
He
নাম্বারটা এই ফোন নাম্বারটা
got selected for appointment in the 2016 SLST recruitment process. Stop. After the entire process got nullified by the Honorable Supreme Court, the petitioner intends to take the benefit of paragraph 47 of the judgment passed by the Honorable Supreme Court on 3rd April 2025 in civil appeal arising out of SLP C number 9586 of 2024
কত লিখছে ও?
within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. Stop. the DI has
3:30 হয়ে গেছে ভাই,
requested the school
মেইন দরকার।
to allow the petitioner in their previous service following the Honorable Supreme Court's judgment. Stop. The petitioner has been specifically found to be a non-tainted candidate and would be entitled to the benefit in terms of paragraph 47 of the judgment. Stop. Prayer has been made to direct the school to permit the petitioner to resume his duty. Stop. Learned advocate representing the school submits upon instruction that since the school is a DA-getting school and the number of students in the school has reduced from the number of students which were studying in the school at the time when the petitioner was serving, it will be difficult for the school to accommodate the petitioner. Stop. The school does not generate enough funds for payment of salary to the petitioner. Stop. The paragraph the school also takes the stand that the petitioner would not be entitled to be reverted to a DA-getting school not provided if the teacher-student ratio does not permit resumption of service of the candidate. Stop. Paragraph that apart, an issue of maintainability of the writ petition against the school has been raised. Stop. Paragraph. Upon hearing the parties, it appears that admittedly the petitioner has been found to be an untainted candidate and would get the benefit in terms of paragraph 47 of the judgment referred to herein above. Stop. As the school has raised an issue with regard to the student-teacher ratio and decrease in the number of students for which fund cannot be generated for payment of salary to the petitioner, the issue is required to be decided by the court. Stop. The school and the district inspector of schools both are directed to file affidavits disclosing their respective stand. Stop. The district inspector of schools shall particularly address the point as to whether the petitioner has address the point as to whether the petitioner can be accommodated in any other school in case the student-teacher ratio of the Gyan Bharati Vidyapit does not permit the petitioner to be reappointed in the said school. Stop. Such report shall be prepared and circulated by 12th August. Release the matter on 21st of August 2026.
It's my duty to kindly see page 74. He has been already recommended to a upper primary school by the commission on 19th of February 2025. He
Which
has been
page?
recommended. That is page 74. I'm grateful to my learned friend, Milord. He has pointed it out.
Yes,
He is
after-
presently working, Milord, in that previous school, Milord, in Jalpaiguri.
Jalpaiguri.
Yes, but he has been recommended. He has, for some reason, I do not know, Milord,
No,
that
no,
is
for some reason, my lord, after the judgment, my lord, I have not accepted this. I want to accept, my lord.
No,
this.
now the time period of acceptance has also expired.
Because the 47, at that paragraph 47, my lord, the benefit has been given to me. That is why, my lord, I want.
Milord,
to
your
accept
lordship may permit him just to
His
cut short the entire.
Salary,
In
is-
this is higher.
which one is higher? Upper primary is
Ah,
higher.
this. My past service.
Private is past service.
My, obviously, I joined, my lord, কবে join করেছি? 2011.
Milord, I don't think, Milord, this continuity is there, Milord, in this sort of a.
Obviously.
This
Continuity, the Supreme Court says there will be continuity.
for government.
And my lord,
So if he gets a government school, he will prefer that.
Yes, this is the government school.
This is a fresh appointment altogether.
Oh, আচ্ছা, সেই জন্য। আচ্ছা, আচ্ছা। That
and
is
my lord,
also
my lord,
fresh appointment.
if it is not extended beyond 30.
We'll come back.
This
12th
is-
of August, my lord, is
this
kind enough to
is-
fix 21st. হবে?
Returnable on 21st, by 12th you file your
Very good.
affidavit.
Great.
My lord, if it is not extended.
হবে
beyond
হবে
31st
দাদা হবে
July,
করতেই হবে না 31st জুলাইয়ের মধ্যে রিক্রুটমেন্টই হয়
Then I will be out.
Because see,
it has to be extended.
I inquired from Dr. Patro and he
Yeah,
said
yeah.
that he'll take steps for extension because the whole thing is in a lurch.
Yeah.
Nobody knows
Great.
what's going to happen.
Otherwise, my lord, we'll have to face contempt.
I'm grateful to your
My lord,
lord.
affidavit or my lord, the report in form of affidavit.
Whatever,
My lord, only if it
something
is-
should come. Something should come by way of an affidavit.
ওই judgment গুলো দিন তো আমাকে একটু।
Restoration.
of 2010.
When is
Restoration
the
application
applicant?
is of 2010.
আরেকটা আছে, এটা আছে,
Possibly has become infructuous. We are
Very well dismissed.
grateful. My lord.
না, না, না। হ্যাঁ, হ্যাঁ, হ্যাঁ। আর ওটা,
Item number 326. My lord, in all these, all four matters, my lord, I have instruction to appear on behalf of the state. I am instructed that no paper is available with the original side advocate on record.
এটা আমার নেই।
Dismissed.
এটা পরে দিয়ে
Dismissed. Dismissed.
Grateful.
আগের অর্ডার শিট দেখি ফার্স্ট টাইম হিয়ারিং বলছে এফিডেভিট কোথায় 2020 matter is it appearing for the first time today display হয়েছে তো হ্যাঁ এ তো গার্নিশি প্রসিডিংস আছে তাহলে এখানে আচ্ছা দাঁড়ান according to procession appearing on behalf of the petition and the college is a fully funded come where the salaries of the employees are paid according to submits that in contribution for ESI would be made by the government and not by the petitioner. He prays that the money be appropriated by the ESI will be kept to under group 3 released
মাই লর্ড, আমি কিছু বলতে চাই, আপনি যদি একটু আমাকে পারমিশন দেন।
এটা তো বলার সময় নয়
a big issue, my lord. Small meeting, 200 to 250 gathering, my lord, only.
21st of July is Tuesday.
My lord, in support of that meeting, one campaign meeting will be held at Mantesra block in Bardhaman. Only small meeting, my lord, Prime
A
Minister.
small matter 1122. When will you file and when will the matter be heard?
My lord, leave may be granted. I will file urgent basis, my lord. Personally.
Is it affirmed? Not yet
Not
affirmed.
yet affirmed, my lord.
Then until and unless the writ petition is affirmed, leave will not be granted.
My lord,
Get it affirmed.
after
Call
affirmation,
the list. You get it affirmed, then I'll see. অনিমেষ বাবু আসেনি? আসবে না? ও yes. হ্যাঁ? Yes.
Yes, my lord. Writ petition number 27558 of 2025.
2025.
Yes, my lord. 2026. My lord.
All right. Year.
Same, my lord, same.
My lord, in item number 3, my lord, Miss Taposi Balu Sinha was had appeared in the matter, my lord, but her name has not been included, my lord, for the state. Obliged, my lord.
ওনার নামটা রেকর্ড করে দেবেন, স্টেট কাউন্সিলের নামটা।
Petitioner
Yes.
surname is, my lord, wrongly written, my lord. Surname is, my lord, Bagchi, BSC, BAGCHI, instead of, my lord, BAHCHI.
All right.
My lord, correction is, my lord, paragraph, page 2, my lord, paragraph 11, my lord. Date of retirement instead of, my lord, date of death. And
Yes.
My lord, I am for the petitioner, my lord. I have served the school service commission that I have mentioned and the matter will appear today. My lord, the issue has been decided by your lordships, my lord. My lord, I was
Who is appearing for the commission?
Lord, Dr. Patro, my lord.
Where is he? Any of his juniors?
Just saw him.
Is he coming?
Yes, my lord. I just saw him outside sometimes 10 minutes.
I'll pass it over.
Because
Time being pass over.
their presence is required.
Time being pass over. Wait. Yes, place it.
My lord, the issue is, my lord, I was appointed in classes 9. At the same point of time, my lord, I applied for upper primary and 9. My lord, when I was in employment, my lord, I was impaneled in upper primary and was called for first phase council. My lord, thereafter, your lordship knows 9-10 appointment gone. Now, my lord, before that, the counseling was over, my lord. My lord, now I want to participate in the counseling. In the meantime, what happened, my lord? The division bench passed an order directing that all the upper primary who are waitlisted or impaneled should be given appointment. But my lord, certain candidates in the wait list were not given appointment, they filed a contempt application. Ultimately, the division bench directed, no, you have to arrange for the vacancies, convert those and give them appointment. So my lord, I also fall within those categories, though I am not in a waste lead, I am in a better position in panel. Now, my lord, counseling, they have issued a notice that 21st is the counseling date. I want to participate in the counseling. Now, my lord, this is the notice. Your lordship has passed a judgment. I'm not giving it right now. Your lordship is aware of that. My lord, this is the counseling notice. I want that. And my lord, pursuant to your lordship's judgments, those candidates were called for counseling and ultimately recommended and appointment were also given. So, my lord, we stand on the same foot. So, my lord, we should also be allowed to sit in the counseling and get a recommendation.
The counseling of the waitlisted candidates will commence from such and such at the office of the such and such. You are an impaneled candidate.
Impaneled, better situated.
No, so what happened to those impaneled candidates?
Impaneled candidate, all were given.
Why were you left behind?
Because, my lord, at that point of time, my lord, when I was called for counseling, my lord, I was in employment in. That is the
Right. So, and this is in the, what is to be done with these type of candidates?
My lord, firstly, they cannot wriggle into this round of counseling.
Yes, this I
This is
understand.
purely on the basis of the contempt. Vacancies have only been given to those candidates who are the leftover waitlisted candidates. They are not them. There are about 40 candidates or more, maybe, who remained absent, approached the court, and the court directed, if I remember correctly, even my lord has passed similar orders, that after accommodating 1241 candidates, if there are any vacancies left, then we will call those candidates, and if there is any vacancy,
Matching vacancy.
for them, only then will we consider them. So this notice neither helps or harms these petitioners. Let them wait, let this counseling conclude. Let us come back to the division bench. Let us tell the division bench whether we have successfully accommodated all 1241, filing our affidavit as directed. After that,
How many vacancies are there, you said?
we require 1241.
1241.
The government has managed to give us only 1177. So there is quite a big shortage. So how that part is to be solved, that will also have to be placed before the court. When this entire exercise is complete, only then does the question come of entertaining these absentee candidates who are actually debarred by the rule. These orders were passed purely because your lordships had directed us that they are job losers. Now they want to come, so we should treat them
orders were also
sympathetically.
affirmed by the division bench.
It is all right, but then
My lord, I tell your lordship another fact, my lord.
in this
Total vacancies
process,
were 14,000 and impaneled was around 11 or 12,000. So, my lord, the division bench directed, my lord, normally your lordship will not find an order that even all waitlisted candidates should be appointed. But since the candidates were less and vacancies were more,
everybody got a chance.
Everybody got a chance. Now, my lord,
So
since we are
everybody did not get a chance. May I just interrupt here? Everybody did not get a chance. It was a misassessment of the vacancy position because category-wise, there were not enough vacancies for all categories. We still have 5,000 vacancies from the old stock.
But not matching.
But not a single candidate can be pushed into any of those vacancies, not even one candidate. That is why this 1241 got stuck.
Matching vacancy is the problem.
Matching vacancy, my lord, that was the very problem before the contempt court, my lord, division bench. That is why the division bench directed you ask the government, you convert those matching vacancies. So, my lord, for waitlisted candidate, if it can be done, my lord, we are impaneled. The same thing can be done for us also. We are
That
not,
is a separate process altogether.
That may
So
be
how
done
do you
in
get the
separate
benefit?
process, my
Yeah,
lord.
so that is what Dr. Patra is saying, that you do not get
My lord,
benefit of
there is
this.
no point, my lord, keeping this matter pending. I may not be get a chance in the 21st, but my lord, they can, after this is over, they can come up with our case.
So
and do the
wait,
same.
Just
Yes,
wait
this is
for some
premature
time.
at this
Let
stage.
that be recorded. The 21st is not for ours. It will be considered.
What is there to be recorded? It is not for you. Nobody says. It's you saying.
Sent in
There
the
was a
notification
Yes,
that it is,
First SLST upper primary
yes, and in compliance with the order passed
of
by
the
the
division bench.
division bench in the contempt matter.
Please come.
My lord, there was also a direction for filing affidavits. My lord, it can be
Petitioner intends to seek benefit of the notice dated 7th July 2026, issued by the Secretary, West Bengal Central School Service Commission, whereby dates for counseling for the post of assistant teachers in connection with first SLST for upper primary level of classes 2016 has been issued. Stop. It appears from the notice that the same has been issued in compliance of the order passed by the Honorable Division Bench. Stop. The petitioner does not fall in the same category of candidates in whose favor the order was passed by the Honorable Division Bench. Stop. The petitioner stands in a completely different footing. Stop. The petitioner is an impaneled candidate in the selection process of the West Bengal Central School Service Commission for upper primary classes, but the date for counseling of the petitioner is long over and the petitioner remained absent on the date of counseling. Stop. Whether the petitioner may be granted further opportunity or not is to be decided. Stop. Did you file a report or anything of this sort?
I don't know.
There was a direction.
There was a direction. Yes, there is a direction for opposition. And Selikun, the commission is directed to file the opposition within a period of 4 weeks, reply if any within 2 weeks thereafter. Liberty to mention.
Deeply obliged.
My lord, 7 same.
7 is same.
Grateful.
Number 8.
The petitioner Miller was appointed as a headmaster of the school. Now, Miller, thereafter, Miller, while in employment, she was suffering from breast cancer, and this breast cancer she was suffering from August 2022. Now, Miller, the date of superannuation of the petitioner is 31/12/2025. Miller, kindly note the date, Miller, because I will be referring to certain letters. The date of superannuation is 31/12/2025. Now, Miller, kindly come to page 48. Your losses will be pleased to find that pension payment order was issued.
Respondent number 6 and 7.
Miller, respondent number 6 and 7 at the school authority. Miller, the president of the school.
The school, are you there?
School.
And the school is the answering respondent? Or
He is
the
the
state?
answering respondent because of the school, Miller. Because what happened, Miller, I will indicate to my lords that, Miller, after this pension payment order was issued at page 48, your losses will be pleased to find that, Miller, one letter was issued to the particular, Miller, the president. That, Miller, that this is dated 19/12/2025. This is the letter issued before retirement. Now, your lordship may kindly consider that I had handed over the charge, and that will be evident from page Miller 49.
kindly come to the resolution at page 49. Are page Millard, one second, Millard. Page 49 is a letter, Millard, where I have indicated that this is to state that I, Mitali Banerjee, headmaster of the school, have received the PPO from the such and such. I am requesting to take necessary steps for handing over the charge on 31/12/2025 afternoon, the 8th of March 2018. Now, this letter was issued on 19/12/2025. Now, then, Millard, your lordship may kindly come to page 50. This letter, Millard, where Millard, the assistant headmaster indicates that I am, second paragraph, I am suffering from certain health issues such as hypertension, hyperglycemia, and hypertriglyceride levels, and I am now under regular medical treatment and supervision of Dr. P.K. Mukherjee. Due to medical conditions, I have been advised to avoid excessive stress and workload. Then I most humbly request you to constitute a temporary subcommittee, including myself, for carrying out the handover to take over process smoothly, transparently, and in accordance with the rules, so that no administrative inconvenience arises. Now, next page, Millard, page 51, your lordship will be pleased to find that Millard, a subcommittee, though in the rules,
there is no
I
such provision.
don't find any provision. I need not, Millard. I know that if I say this thing to the court, this will be my ignorance. Now, Millard, I say, Millard, with the greatest of respect, kindly come to one, Millard, resolution, that is page Millard 46. Millard, this is very relevant, Millard, page 46.
There is an allegation of financial discrepancy against you.
After retirement.
Yes.
Now, after retirement, they indicate that there is some. Now, Millard, that also your lordship may kindly record. Millard, your lordship may kindly take into consideration the language of the letter. Your lordship has taken note of this letter, I think, Millard, that is letter dated 17/1/2026. Yes. Now, Millard, this was issued after retirement. Now, there is no, Millard, allegation. There is no allegation of financial discrepancy or that I have committed any particular fault. Now, Millard, your lordship may also kindly consider page 46. Page 46 for a second, Millard, kindly see what is the resolution. They want that I should hand over the charge. Just for a second, Millard, your lordship may kindly, Millard. And Millard, the last order which was passed by my lord, Mr. Justice Ritobroto Mitra, Millard, had dealt with all things.
Who's for the state in this matter?
I don't know. State, Millard, no one appeared from the beginning. I did not find. You sab korochis? Millard, for my satisfaction, Millard, kindly come to page 46, Millard. I appeal to my lords.
Yes.
Millard, I am just reading from the পরিচালনার জন্য অ্যাসিস্ট্যান্ট হেডমাস্টার কাম টিআইসি নিযুক্তিকরণের কথা বলেন। সেই মোতাবেক অর্ধ এসএমডিসির সভায় সর্বসম্মতিক্রমে সিদ্ধান্ত গৃহীত হয় যে বিদ্যালয়ের সব প্রধান শিক্ষক চন্দন মণ্ডল মহাশয়কে আজ থেকে বিদ্যালয় পরিচালনা সমিতির সমস্ত প্রধান শিক্ষিকা পুনরায় যোগদানের পূর্বদিন পর্যন্ত এইচএম কাম টিআইসি হিসাবে অর্পণ করা হলো। তার সঙ্গে আরো উল্লেখ থাকে যে প্রধান শিক্ষিকা মিতালি বন্দ্যোপাধ্যায় মহাশয় 1/4/2024 থেকে ছুটিতে আছেন এবং সেই সময় থেকে আজ পর্যন্ত প্রধান শিক্ষক চন্দন মণ্ডল মহাশয় বিদ্যালয় পরিচালনার যাবতীয় কাজ করে এসেছেন। তাই উনি এইচএম কাম টিআইসির হিসাবে চার্জ অ্যাসিউম করেছেন 1/4/2024 থেকে। And Millard, they have also reflected the accounts that who will be the persons, Milord, kindly see the অর্ধ সভা সম্মতিকরণে সিদ্ধান্ত গৃহীত হয় যে পাঞ্জাব ন্যাশনাল ব্যাংকে বিদ্যালয়ের নিম্ন প্রদত্ত ব্যাংক অ্যাকাউন্টে গুলির আর্থিক লেনদেনের জন্য 3 জন সদস্যের মধ্যে HM কাম TIC ম্যান্ডেটরি এবং বাকি দুজনের যে কোনো একজন অর্থাৎ মোট দুজনের স্বাক্ষরে টাকা লেনদেন করা যাবে। অনিমেষ দাস, চন্দন মণ্ডল, শঙ্কর মাঝি।
Since when are you serving as the headmistress?
Milord, Milord, I was appointed as headmistress on 16/7/2019. That my lords will get it at page 26.
All right, 2019. You are not there on and from
Milord,
1st of April. That means 31st
I was
of March 20.
because of sufferance of the cancer, Milord, I sought for leave that I had availed leave for 40 days from 22/8/2022 to 30th of September 2022. Then, Milord, after joining, again I had to avail of the leave because I had to take the chemotherapy.
I would like the state to be present.
Milord, I leave it to the court.
What was the order passed on the last
Milord,
occasion?
kindly see this order, Milord. ওই তারে
Which
যশোরের
order?
কাছে ফাইলই তো আছে order. তুই এত হয়ে যাচ্ছিস কেন?
12th of May?
Yes, Milord, this is
Yes.
12th of May. Kindly see the order.
Published at the entire process of denying, depriving the pension due to nothing but depression and malafide. This is your submission. The petitioner asked to clarify certain irregularities.
They were given
Time.
2 opportunities, but Milord, they could not give any instructions, and
No, one thing is very clear that after retirement, all these things should not have come up.
yes.
Why was all
Why
these
not
things-
during the
Actually,
employment?
The petitioner on leave for 18 months, my lord, in special circumstances, my lord. On that reason, not issue any letter. The petitioner is a patient of the cancer patient, my lord. The sympathy ground, not issue any letter for the school authority.
You want to show sympathy?
No,
Show
no.
sympathy now also.
Kindly come to my lord. My lord, at the time of taking over charge, my lord, in the year 2022, he is taking charge of financial and operating the school, my lord.
Yes.
When he is a leave, but without giving any charge, the school authority have no other alternative to fix a form a committee and given a charge to the assistant teacher for day-to-day business of the school by the school authority. But petitioner till date not yet given any charge when he received the at the time of joining, my lord. That is the difficulty. And more than 1,74,000 have not misappropriated the fund, my lord.
So this fund was there when the petitioner took over charge,
That is
right? Thereafter, she went on leave.
Yes.
What happened to the fund? Will the person who steps in not take care?
Day to business, day to smooth running of the.
All right, I have followed it. You give notice to the state once.
Yes.
Please come. None appears on behalf of the state respondents. Stop. The petitioner has retired from service on 31st of December 2025. But despite issuance of the pension payment order in her favor, she is yet to receive her terminal dues as the process of handing over of charge is not yet complete. Stop. After retirement, comma, the school raises an issue of financial irregularity against the petitioner. Stop paragraph. The presence of the state respondent will be very much required for effective adjudication of the instant list. Stop. Let notice be served upon the learned advocate representing the state respondents. Release the matter for further consideration on.
You know, kindly give some precedence because the lady has also now today come. Milord, I asked them.
Wednesday. Wednesday, 22 Tarik.
Very good. Milord, I will serve a notice upon the learned government leader because now
Yes,
there
yes,
is much
government
of
leader.
confusions going. Because
Government leader.
when anyone is going, saying that if
Service
no
is
date is
taken under.
mentioned, then that will not be accepted.
In the can on 22nd or 23rd or 21st.
সেটা
Some
তুমি
difficult
যা
22nd,
খুশি,
my
আমার
lord.
কোনো ইয়ে নেই।
22nd there is
Some difficulty,
difficulty.
yes, madam.
In that case, 24th, next Friday.
And then
24.
24.
Madam, this petition is affirmed, my lord. It will be fixed after 2 p.m. my lord.
After?
After 2 p.m. today.
After 2 p.m. it cannot be done. You have to serve
My lord, we
at I can give you leave Monday, you can move before the regular bench.
Meeting is fixed tomorrow, my lord.
Doesn't matter, the main meeting is on 21st.
This is the preparatory meeting.
Preparatory meeting, you go on, preparatory meeting is not required. Leave to move the regular bench on 20th.
My lord, in item number 9, I beg to appear on behalf of the petitioner, my lord.
Lordship, I am led by Mr.
PCI is the
Torunjyoti Tiwari, Lordship. Lordship, I am led by Mr. Torunjyoti Tiwari. He will appear in this matter on behalf of the PCI.
On behalf of the
My lord,
PCI, Lordship.
in this matter, my lord, the petitioner before your lordship
Pharmacy Council.
Pharmacy Council.
is the answering respondent, my lord. In this matter, my lord, the petitioner is a institution.
Where is he?
Lordship, due to some personal difficulty, he could not come to the court today, and we are the answering respondent. So, Lordship, kindly
Want
take up.
adjournment?
No, Lordship, kindly take up the matter after 2 weeks, Lordship.
After 2 weeks?
Yes, Lordship, because next week there is assembly, so he could not come to the court.
Why will the matters wait?
Lordship, kindly, Lordship.
No question of kindness. The petitioner
Lordship, we
is,
need to take
the
instruction
matter is
as a.
there in the urgent list. Please engage somebody else who can take it over. It cannot be urgent for 2 weeks.
My lord,
All right.
my lord, the matter is concerned, my lord, the petitioner is a
It cannot
task.
be done because the primary pharmacy council is not here. I can keep it on Monday, not today.
Grateful to your lordship, because there
Urgent
is
for
certain urgency, my lord.
Urgent for the day on the prayer made on behalf of the learned advocate representing the Pharmacy Council of India.
Grateful to your lordship.
Praying for short Passover.
On behalf of?
Shashanshu Bhattacharya.
He is appearing for the state. Who is answering respondent?
Service Commission.
All right, yes. Tell him to come. Yes, please.
My lord, petitioner initially appointed in 2010. Thereafter, for getting better opportunity, she again appeared in 2016. Now, my lord, 2025, everything has been cancelled. She was reverted back in a particular school. Before reverting back, she made a specific prayer that I am suffering from serious illness, my lord. I have all the documents to show. Now, without considering the same, they recommended it in a school near Diamond Harbour, my lord. Now, my lord,
You are a resident of?
Sonarpur, 72 kilometers distance. Now, my lord, I made prayer. Kindly consider my situation. Now, considering my prayer, they again recommended it in his school, also in Diamond Harbour Division. I joined there, my lord. Finding no other alternative, I joined there. After joining, my lord, I came to know that that particular post is a supernumerary post. And the pursuant to the order of this honorable court, that post has been cancelled.
So there is no post where you can be accommodated now?
Yes, my lord. That post has been cancelled by the pursuant to the order, since it's a supernumerary post. Again, I made prayer. But considering that my prayer was not considered, and again recommended in school and Diamond Harbour Division. There are so many schools located nearby the Sonarpur, my lord. I have mentioned in my representation name of the schools also. My lord, that has not been considered. Another thing, my lord, another important thing, my lord. The post is a work education. For the subject work education in the second SLST, there is no recruitment. This for the subject work education, there is no recruitment for
No,
the
that is
subject
because it is under
work
a different
education.
rule. It is not under the rule which is
Yes, so what is to be done?
So, my lord, kindly page paragraph page 83 once. Page 83. Considering my prayer, the School Service Commission ask the Commissioner of School Education to take appropriate steps. Kindly see page 83. That has not been considered, my lord, till date.
By the Commissioner of School Education?
Yes, my lord, Commissioner of School Education. Let it be considered, my lord.
Yes.
My lord, firstly, the candidate in the original appointment was recommended in a school in Diamond Harbour, which is the same district where this candidate resides. That is evident from paragraph 5.
No, 1 minute. He says page 83 has not been considered. It is your request to the Commissioner?
page 83.
28th of April, 26.
Yes, that's it. That letter is there, but before
Right.
that, he has already been recommended thrice. He has been recommended in the same subdivision also. His original school was Diamond Harbour. His next school was Diamond Harbour. After that, again, he was recommended in another school within the district of 24 Parganas South. So there is a limit to how close the candidate wants to come to his or her house. Now, this letter is there. No doubt it was shown also before the coordinate bench. And there was a, I would say, a request. I'm not sure whether it was recorded, that the state is to take instruction with regard to the vacancy, whether there is any vacancy near to the petitioners. That instruction has not come. Now, why my learned friend is directly coming to 83 without mentioning this fact, that it was adjourned twice. It was adjourned twice on the ground of the state to enable them to bring instruction with regard to a vacancy.
Yes, that order your lordship passed. Yes, we yesterday your lordship passed an identical matter directing the state authority to ascertain the vacancy. Similar
Yes.
order may be passed. I have
No,
no
this
objection.
matter, I think the order was
Similar
is
order-
already there.
Similar order may be passed, my lord.
Yes, my learned signature is there.
You please come to page 83 of the writ petition. You are answerable. You will be representing the commissioner. I want an answer from you. All right. Page 83 is the request from the commission to the commissioner, and you have to answer.
That's
What
why I
is
mentioned.
What is your health issue?
Yes, page paragraph 12. Kindly see once, paragraph 12.
Why don't you get a residence close to your school?
How acute condition? Kindly see paragraph
Why
12
don't
once.
you? Why see there are candidates who are running from pillar to post to get a job.
My lord, I know.
You are with a job.
I know, my lord. Kindly see once paragraph.
Why
12.
don't you get a house and accommodation close to your residence, to the school?
Paragraph
Why
12.
the school has to come close to the house and not the house close to the school?
My child is studying in a school near my residence. That's
Let the father take care of the child.
Paragraph 12. Kindly see once.
Are you the father
how
or the
acute
mother?
condition is.
You are the mother. Let the father take care of the child.
Paragraph 12 once. Kindly see once.
See, the court is not an expert. What is your medical issue? You will know, your doctor will know. The court is not here to look into this.
Lordship will
What
be able
you are
to ascertain
seeking-
the nature of
What
medical issue.
you are seeking is mere sympathy. 3 rounds you have been recommended and you are refusing.
Not refused it, my lord. But I joined one school. That school, my recommendation has been cancelled due to my supernumerary post. I've stated on. Not 3 schools, 2 schools, my lord.
All right,
My
2
lord,
schools.
I just make
What-
one suggestion. It might solve.
Supernumerary post, appointment cancelled and another
This,
school I joined.
this
my lord.
recommendation is pursuant to the order of the Supreme Court, that those who are already in employment, you will have the option to go back. Let the candidate go back and join. It is a case of the candidate is claiming to have medical issues. There is no requirement to wait for 5 years for applying for transfer.
The
Let her
candidate
join.
can always join
Yes,
and
let
get
her join.
a
And
transfer
now let her,
application.
because technically she is actually not working anywhere. She has to join, start working, and immediately apply for the
I am
transfer.
working in a school, my lord, presently at Diamond Harbour. But I am working present school in a Diamond Harbour, my lord. I am working.
School.
Yes, my lord.
Yes, there's the procedure for medical.
Which school?
Yes, my lord. Kindly that page 11, my lord. MP Gurushi Adarsh Vidyapith.
Page.
Para 11, page 7, my lord. That is school.
Where is the document?
Documents, my lord. That is at my lord. Annexer P5. Page 44. Page 44. Page 44, my lord. Yes, my lord. I am
That is
working.
even better. Now let her apply for transfer.
I
in
am
the
working
medical
there.
ground.
And thereafter, second recommendation again, my lord, then Diamond Half Division, my lord, kindly consider, my lord, that aspect, my lord, let it be
What
considered.
is to be considered? I do not understand. What is to be considered? You are there in a school. You sought for transfer. You have been recommended in another school. You are also not willing to go over there.
Not willing to go, but this particular school is, my lord, supernumerary post, my appointment has been cancelled.
Page 44.
Page 44.
Appointment has been cancelled.
Yes, my lord, pursuant to the order of the of course, this is supernumerary post.
All right.
And they recommended the next, my lord, page,
If page
page
40
78, page 78.
if page 44 is cancelled, how do you say that you are still working in this school?
Well, it's a supernumerary post, so let them do not cancel that particular post. Well, let me remain there. Let me remain there.
Now he's saying a different thing.
Let me remain there.
Post.
Well, it's a supernumerary post. This is my specific case. My lord, kindly record it. And the honorable court passed the order. No supernumerary post will be there, my lord. No appointments
No,
will
I
be there.
don't know of such order.
You are still working in page 44 school.
My lord.
Keep working over there if you are happy. Why do you want
Well,
to
kindly take it tomorrow, my lord. Kindly take it tomorrow. My lord, kindly, my lord. Kindly take it tomorrow. I shall take instruction, my lord. My lord, kindly take it tomorrow.
No, I'll pass it over. If you want instruction, you come back.
My lord, she will be in
No.
school. My lord, she will be in school, my lord.
Doesn't matter. Let her remain in school.
My lord, then kindly take it at 2 p.m., my lord.
You are mixing up very many things together. Once you say it is supernumerary, it has been cancelled.
I have written, my lord.
You've been cancelled.
And supernumerary is sub judice. It is not cancelled.
And assuming it is cancelled and you are there, the
is why-
state will accommodate you
That is
somewhere
why
else.
they recommended me in the second school. No, what, my lord, on what ground they recommended me in the second school? Why? What is the reason? Because this is the supernumerary
The
post.
second recommendation.
Yes, my lord. Kindly see. Second recommendation is at page 78, my lord. 78. No. 44 is the first one.
Acha,
That
Mohirampur
was
AM,
reverted back. That was reverted back pursuant to the order of the Supreme Court.
Mohirampur AM Girls High School,
My lord.
South 24 Parganas.
Yes, my lord. They recommend why?
24th of February
But
26.
what prompted them for recommending me? I am working in a school because that is the supernumerary post. Well, that was reverted back. First recommendation is that was reverted back pursuant to the order of the Supreme Court, my lord.
So you stay over there.
Yes.
Page 40.
No, Supreme Court is page 22.
Page 41.
That was 11-12 recommendation at page 22. That has been.
Yes, November 25. But why did the third recommendation come? Transfer. You so much of pick and choose cannot be
Lord,
given.
kindly take it, my lord, at 2 p.m. my lord, I shall take instruction. Kindly take it. At 2 p.m. my lord, I shall take
2
instruction.
p.m. I have fixed matters. Then 3 p.m. if possible.
Prior to rising, please come.
My lord.
Otherwise, it will remain in the list as it is. No.
My lord.
Prior to rising, before recess.
Before recess. Before recess.
Actor show?
Today there is no resolution, isn't it?
Yes, my lord, resolution.
Today also there is a resolution.
3:30, my lord.
Chitragupta is standing at the back. Chitragupta.
ভালো নাম দিয়েছে তো
ঠিক আছে
Now, my lord, before you start, my lord, the suit which was filed dismissed for default, restoration application, miss case also dismissed on merit. So today there is no suit even.
My lord, I communicated the same and the notice was served upon the Mela organizing committee.
What happened thereafter?
My instruction is no.
Mela is being held.
No
Mela.
Stall is
No Mela. All right.
I see the my lord, the
You are directed to obtain permission, also that you are requested to produce a permission.
served upon them.
Very well.
Without obtaining any permission or upon the value owner, my lord, no Mela should be conducted.
But in fact and in effect, that is not been adhered to.
What
Mela-
is being done? The Mela is being
My client is present here, my lord. I've taken instruction
I'll direct the SDO.
to remove it immediately.
Please come.
Can you record that they suit?
None appears on behalf of the private respondents despite service by the office of the subdivisional officer Malda Shodor, Malda. With a notice dated 26th of July 2026. Stop. The private respondents were notified to produce copy of the permission / NOC from the landowner / venue owner, filling which the permission for using the loudspeaker
Can you see? Can you see? Just now it is handed over to me.
for permission.
In fact and in effect, there is no case.
Permission dated 2nd July 2026 would be deemed to be cancelled with immediate effect.
Loudspeaker.
Stop. Paragraph. As none is present on behalf of the private respondents, there is nothing on record to suggest that the landowner / venue owner issued any no objection or permission for using the land, which is using the land in question for conducting Rothomela. Stop. Next. In view of the above, the court is constrained to direct the subdivisional officer, Malda Shodor, Malda, to take immediate steps to stop the Rothomela if already started, and take all necessary steps to ensure that the Mela is not conducted at the subject premises.
The
Stop.
removal of the structures is already installed.
As the petitioners do not object to the holding of the Ratho Jatra, the same may be permitted to be held. Stop. Paragraph. The stalls set up for purpose of the Mela should be immediately dismantled and removed. The writ petition stands disposed of. The instruction from the subdivisional officer, Malda Shodor, Malda, dated 16th July 2025, showing the service of the notice upon the secretary of the Ratho Samoskar committee, signed on 16th of July 2026, filed in court today, be written with the records.
Some comment is required, my lord. What is this? It's trying to overreach.
No, possibly not, because the permission was continuous. Ratha Jatra, Mela, mic,
No, my lord,
everything.
the order was that it should not. To overreach that, he said only loudspeaker will not be played.
The date is there. Second,
Yes,
the
that
date
date
is
is there.
there, which
My lord,
covers everything.
Can you record that the suit? I've handed over, my lord. Now there is no existence of suit.
But then does it?
My lord's observation was the suit is pending. That's why my lord passed an order. I've handed over to them.
ওই যে ওখানে রয়েছে ওই যে ওইটা Suit was filed by them.
By them, that was this is for default. Restoration miscase dismissed on
The
merit.
civil suit which was filed by the private respondents, being OC number 81/84, has been dismissed by the court. Copy of the order dated 12th July 2026, filed in court today. Now, 12th July and 15th of July 2026, filed in court by the learned advocate representing the petitioners, be written with the records.
I appear for the state respondent.
But I am a victim of anarchism. I run a school, suddenly somebody comes, claims to be the officials without any order, without any previous notice, puts a lock. I immediately complain to the respective police officer, the police start an investigation, who have done this, nothing did.
Who are the persons who had put the padlock?
That's my query.
You don't know.
That's why I say I am victim of anarchism.
All right. Where is your representation before
Kindly
the
come to page 132. Immediately I write in
Their allegation
Wait. Don't get so excited.
that I write
The officer in charge.
Jumdar police station that I am writing, so kindly skip over the first paragraph. That today at approximately 3:30 p.m. certain individuals identifying themselves as representatives of the office of the district magistrate Howrah arrived at our school premises, accompanied by the local police. Without serving any prior notice or legal intimation, they broke open the padlock and forcefully took illegal possession of the school.
The school is running?
No. Now because of this, I can't run. The guardians have.
How many students are there in the school?
380 and plus.
What is happening to those students?
They are online classes. They are now out of school. We have to attend some online classes.
Which board is it affiliated to?
This is not an affiliated school.
All right.
This is unaffiliated school. We run it
Till which class?
1 to 8. 8 up to class 8. Lordship knows 9, 10 requests for sent up and affiliation.
All right. So you approached the officer in charge, page 132.
Yes.
And this is in 3rd of June. Thereafter?
Nothing. That's how we have to approach your court.
No, sir, page 140.
140 is again another complaint.
No, complaint. Page 1.
29th of June, you were...
On 13th of June, the government of West Bengal sub-inspector writes me a letter. I do here be informed that as per the BSP portal, Tawhid International has a total student of strength 381. If the guardians of the students are willing to admit their wards to any government school, under the West Bengal board, arrangements can be made for their admission in the following schools.
Guardians do not want
But it is the way of taking out the students.
গার্জিয়ানরা বলেছে আমরা চাই
And the guardians they will be responsive. We are not at all willing to go to any government school.
All right. Yes. What is your stand?
The stand is
Who has instructed you? Which authority has instructed you?
DI has sent me the WhatsApp
All right.
message.
What does it say?
Just allow me to read once. Now, my lord, it is a subject report on the...
You tell me the gist. Don't read. Tell me what it is.
The school has been operated since 2015 without obtaining recognition. This is first point. No objection certificate, NOC or affiliation from the recognized education board. Number 2, the institution is functioning from the first floor of a commercial market complex, namely Jedar Fancy Market, directly above gold processing units involving chemical usage and potential fire hazards.
in the downstairs. Now the school lacks a valid fire license, emergency exit routes, and the necessary structural safety approvals. Despite having an enrollment of 381 students, the school has only one entry-exit point and a total of 5 toilets, which is grossly inadequate to the mandatory norms prescribed under the RTE Act. Now, kindly, Lordship will kindly turn to the next page. In view of the great safety concern, the school premises were sealed on 3rd of June 2026 by the local administration with the assistance of Domjur Police Station to safeguard the lives of the students. On the same day, the inspection report was forwarded to the officer in charge, Domjur Police Station, for investigation and for taking appropriate legal action against the school authority. Malad, this is purely on the safety measures. I am
Did you
concerned about-
communicate? Did you communicate this to the petitioner?
I do not know as of today. I don't have any instruction.
It should have been intimated to the petitioner.
Yesterday at 11:05.
All right.
I got
381 students, and this is the way you are running a school.
this is absolutely safety.
1 minute, yes.
Measures and the safety measures relating to the building, this duty of the building owners. There has been no.
That is different. You are running a school in a building which is unsafe for students.
Who says so?
I am
After taking this without illegal action, I approach the court. This comes. But that's I say is anarchy.
You file this by way of a report.
The Lordship is asking me to file a report.
Yes.
Everything is here in the WhatsApp message. My Lord will kindly peruse once, and your Lordship will be convinced that there is a great unsafety
The
measure.
petitioner.
Let the Miller file a report.
Petitioner number.
I shall. No
Petitioner number.
করবো স্যার আপনি বলছেন
Somebody must take
Petitioner
responsibility.
number 1 and 2.
I shall fire by choice if they are wrong.
The school. And the petitioner numbers 3 to 7. Claims to be the office bearers of the said school. Petitioner number 1 telephone is a public trust running the petitioner number 2 school, and 3 to 7 are the office bearers. ঠিক আছে? They are running a school with total student strength of 381. Stop. This school runs from the junior classes till class 8. Stop. The petitioners allege that all on a sudden, on page 132, 3rd of June 2026, certain individuals claiming themselves to the representatives of the District Magistrate Howrah visited the school and forcefully put a padlock on the said school. Stop. The petitioners approached the police, but no action is alleged to be taken. Stop. The Sub-Inspector of Schools, Domjur Circle, Howrah, by a communication dated 13th of June 2026, proposed for shifting the students of the subject school to any nearby West Bengal government /ICSE/CBSE board schools. Stop. A request was also made to the principal of the school to provide the details of the students. Stop. The petitioners allege that no intimation or communication has been made to the school as to why padlock was put on the school. Stop. The students of the school are suffering. Stop. The school has to arrange for online classes for the students. Stop. Learned advocate representing the state respondents has obtained instruction from the District Inspector of Schools, Secondary Education, Howrah, wherefrom it appears that the DI, by a communication dated 26th of June 2026, has forwarded a report to the Commissioner of School Education regarding the violations of the school. Step. The communication highlights the unsafe condition from where the school is currently functioning. Stop. It is primarily the safety issue that has been raised by the District Inspector of Schools. Stop. Paragraph. The state respondents is directed to file a report by way of an affidavit disclosing its stand by 24th July, next Friday. Release the matter on 31st of July, Friday thereafter. Affidavit of service filed in
Lord,
is taken on record.
I am really apprehensive about the safety of the students.
Yes, call the
And my
next
lord,
matter,
out of
please.
381, 2 have been shifted to other school. My lord, I bow down to your lordship, my lord.
13.
13, we have got the state respondent lordship.
But almost similar issue. But earlier he approached this honorable court, and this honorable court passed an order. Malad, kindly see the order, Malad. Honorable court directed the Commissioner of School Education to consider and recommend the petitioner in any nearby school. Pursuant thereto, Malad, they have Commissioner of School Education have already passed an order and recommended my case to the Commission School Service Commission.
So the grievance of the petitioner has been redressed.
Yes, Malad. Only why I approached this honorable court because they issued board issued an appointment letter asking the petitioner to join the recommended school within 15 working days. Now, since this order has been passed by the Commissioner of Education, Malad, they will take steps in terms of this order, Malad.
13th of July.
Malad, last paragraph, kindly see.
13th of July.
Commissioner requested the West Bengal Central Petition and
Yes, this is our instruction.
The prayer of the petitioner to post her in a school nearby to the residence was taken up by the Commissioner of School Education, and by an office memorandum dated 13th of July 2026, the Commissioner of School Education has passed a formal order requesting the West Bengal Central School Service Commission to revisit the issue of posting of the petitioner sympathetically and to take necessary action for re-recommending the name of the petitioner as assistant teacher of work education in নামটা লিখে দেবেন হিরাপুর মানিকচাঁদ ঠাকুর গার্লস হাই স্কুল within bracket HS in the district of Paschim Mednapur. Bardhaman. Stop next. In view of the order passed by the Commissioner of School Education, the writ petition stands disposed of with the observation that the Commission shall take necessary steps in the matter in line with the request made by the Commissioner of School Education. Disposed.
Not identical matter, not identical order has been passed. Malat, this order is quite eligible. Kindly excuse me. I received it through WhatsApp. Last paragraph. Kindly.
নাগরী সুধাংশু কদম শিক্ষায়তন শিউরি ব্রুম স্কুলে
নগরী সুধাংশু
বদাম
The school must be there somewhere in the writ petition. Did you ever make a request? Nagori Shudhangshu?
Perhaps there it is. Perhaps, my lord.
Page 59, Miller.
Yes, my lord. Page 60, my lord. Page 60, my lord. Serial number 4.
Nagori Shudhangshu Dhain Shikhaniketan. Shudhanshu Bodini Shikhaniketan. ওখানে কমিশনার অফ স্কুল এডুকেশনের অর্ডারের ডেট দিস উইল চেঞ্জ 8th of July 2026 আর স্কুলটার নাম হচ্ছে পেজ 60 তে সিরিয়াল নাম্বার 4 ঠিক আছে ডিসপোজড
Deputy of Placement.
15 Malad, I appear for the writ petition. Malad, this is a case, Malad, where
Time for the state.
Malad, a young Malad. Yes, Malad, the young mother.
Respondent's father. All right. The parents-in-law of the petitioner. The child is with you? Safe? Why is some?
Malad, this is the service. Malad, kindly, Malad, takes the trouble, Malad, to. Malad, I'll briefly, in a nutshell, Malad, I'll state the facts. Malad.
No, you saying the facts. You
Very well.
said your submission was that your child has been taken away.
Yes, Malad, I was thrown out of the matrimonial house. Malad,
It's a
without a
different
child.
issue. Absolutely different issue.
Malad, I am not, Malad, let me, Malad, be very clear. Malad, I am not to agitate my civil rights before the
Right.
lordship. That's one. Number two, Malad, is the fact, Malad, I am here, Malad, for 2 counts. First, Malad, that I have complained of, Malad, a cognizable offense, Malad. I'll show to your lordship how. Malad, that the child has been put into a danger. Malad, he suffers from, Malad, horseshoe kidney, which is a congenital disease. Malad, the child is in need of, Malad, the mother's milk. Malad, which is being deprived. Malad,
What is the age of the child?
8 months.
Yes, 8 months. Mother's milk is not mandatory.
Malad, I shall, Malad, try to, Malad, assist your lordship, Malad. The second, Malad, the first is, Malad, the police authority, Malad, they have, by their action and or inactions, my lord, they have created a wall between the mother and the child, Malad. It is a question of right to life.
Why don't you go to the learned courts below where you
I
can
shall,
get
Malad,
orders?
Malad, I shall, Malad, assist your lordship, Malad. This is exactly what, Malad, the other high courts have also gone into. Malad, an order has been passed. Malad, let me, Malad, assist your lordship. Malad, I shall, Malad, directly then come to the, Malad, the position of law.
Prayer that you are
Malad,
making that
Article
the child
21, Malad, right to life of mother. Malad, kindly seize the first prayer. The right to life of the mother and the child, my lord, is envisaged in Article 21, which covers, my lord, the kindly seize, my lord, the first, my lord, prayer B at page 24. My lord, I have asked for a issue a writ on the nature of mandamus, commanding the respondent authorities, particularly respondent number 2 and 3, to discharge their statutory duties, prevent commission and or continuation of offences, and 2, locate and secure the infant child and restoring him to his mother, inter alia, in order to prevent violation, further violation, and or continued violation of right to life of both child and mother.
So the location of the child is there.
My lord,
No issue with location.
may I, my lord, indicate the facts? 14th July.
No. What relief can the writ court
Yes, my lord.
grant
I
to
shall
you?
come directly to that. My lord, wait a second. Judgment are there. My lord, I am, my lord, placing, my lord, 2 judgments. One is of the Supreme Court, another of the Kerala High Court for your lordship's appraisal. This is, my lord, 2025 SCC Online SC 576. I am handing it up. Yes, my lord. Kindly, my lord, sees this is Mother's Purse, an initiative by Iron Foundation versus Union of India and others. Kindly, my lord, directly, my lord, I will not trouble your lordship with much. Kindly, my lord, comes to paragraph 9 of this report, at page 3 of this report.
Well, this is regarding right to breastfeed, my lord, but there are certain observations of the Supreme Court which are, my lord, very pertinent in this matter. Kindly has a look.
Paragraph 9.
9. My lord, I'll place, my lord. In this regard, it starts from.
Yes, please.
Yes, in this regard, it is relevant to discuss the importance of breastfeeding for a child and the rights of nursing mothers. Breastfeeding is an integral component of child's right to life, survival, and development to the highest attainable standard of health. It is an integral part of woman's reproductive process and is essential for the health and well-being of both mother and the child. Experts recommend that children be exclusively breastfed for the first 6 months of their life, and from the age of 6 months, children should commence continuing safe and adequate complementary foods while continuing to breastfeed for up to 2 years of age and beyond. This view is also supported by Section 5A of the National Food Security Act 2013. Next, my lord, para 10. Further, the health of infants cannot be viewed in isolation. Rather, it has to be seen as being linked with the status of women and their roles as mothers and as contributors to social and economic development of the nation. As the right of a child to be breastfed is inextricably linked with the mother, she also has a right to breastfeed her child. Consequently, this means that the state has the obligation to ensure adequate facilities and environment to facilitate mothers to breastfeed their children.
The
Such
issue
a
in this matter.
yes, I appreciate.
Absolutely.
But this is an obiter dicta. I am on that, my lord. But this is because, my lord, 141, Article 141, my lord, the obiter of the Supreme Court, my lord, is also binding. But I shall, my lord, kindly, my lord, permits me to, my lord, cite this. Such a right and
Just wait.
obligation.
Let's understand. Just wait. What's your problem?
My lordship takes up their writ petition. There's an averment. She left the matrimonial home on 24th of March 2026. There are certain WhatsApp communications, my lord, where
Yes, we are also having.
Return, at least for the sake of the child, my lord.
You want her to return?
Where at that point of time, she, as per her writ petition, my lord, the pleading, she left on 24th of March 2026. On 25th of March, my lord, there are several messages, WhatsApp communications where I took the initiative. I asked her to return. I sent her messages.
She is ready to return.
I have talked with my client, my lord. He has no objection if the mother wants to come and spend time with the child. But this contention that he has in him or his whereabouts.
Why spend time with the child? The lady, she can come back to the matrimonial home.
No, she can come back, but my lord, she has filed a 498.
That is different.
There's a matrimonial dispute.
Yes.
She can come every day if she wants, but
she can stay over there also. She is your wife.
Then they need to withdraw the.
What kind of?
Not put conditions before the writ court. Right?
Yes.
Yes.
13.
Yes.
Come.
No object. What does your what does the husband do? Software engineer. Right. And what does this lady do?
She was working. Now I believe she's not working.
But, certain things, my lord,
may I humbly submit?
My lord, there are, my lord,
Time for
some
the
messages
state
also.
lordship.
I did not want to, my lord, draw your lordship to those issues of civil rights. My lord, WhatsApp messages are there. I can hand it up. It will reveal, my lord, what kind of cruelty. But I am not on that here, my lord. I am only on the limited point.
You do not want to go back to your matrimonial house.
See, what is the instruction, my lord? My lord, subject to, my lord, whatever your lord falls from your lordship, my lord. Question of going back to matrimonial house and the matrimonial dispute, my lord. I am today, my lord. I am addressing only on the limited point. My lord, on the right to life of the child, my lord, to be breastfed at this point in life. And my lord, the overall conduct, my lord, kindly sees, my lord, on the Mother's Day, on the every day, the lady has been trying to get back the child.
Whether you are willing to go back to your matrimonial house or not.
My lord, I am told, my lord, yes. But irrespective, my lord, yes. That is the instruction, my lord, that I am told I am ready to go. But, my lord, the issue is, my lord, how, my lord, this kindly considers, my lord, the mother has been kept apart from the child. My lord, Kerala High Court gone into this, issued a writ of mandamus directing delivery of custody of the child. I shall place it before your lordship, right? My lord, on 13th I went.
The first complaint is in the month of
July,
Lord. There's a video, my lord, which I had. My lord,
Child is.
I can place the video.
The court is not going into any matrimonial disputes. This is very clear.
Lordship, may I humbly submit this instruction
submitted by the police authorities pertaining to the allegations that police has not rendered any assistance. Police has provided their ample assistance. Police has escorted the.
Yes, yes.
May I read the instructions?
Tell the gist. Do not read.
My lord, those are not in
The,
dispute. My lord, police went with.
Went with
But
the
then there are other.
petitioner after recovery of Sridhan articles on 13th July.
The issue is
issue
regarding the child. The
After
Sridhan is
recovery
a
of the
different
Sridhan,
forum.
police was informed that there is a child. After recovery of this Sridhan, there is it is reflecting in the report, Lordship, that the police was informed that the 8 months baby is in the matrimonial home. Police then diarized the issue, and they two lady officers went with the petitioner as an escort to.
Oh, when you left the house in March.
In March 24th, my lord, I underwent a gallbladder operation.
In the
my lord.
month
There was
of
a
July,
complication.
FIR
My lord,
was lodged.
My lord, polycystic ovaries also, my lord, those are there.
So
My lord,
in late July, you will not be in a position to breastfeed your child.
my lord,
It's impossible.
my lord, I'll tell you, lordship. My lord,
No
so far
use
as
telling things.
my lord, only thing is, my lord, I want to apprise your lordship.
Police has also informed the.
My lord, the issue is.
My lord, I asked about what is her present health condition. I even pay anything.
My lord, ওটা ছেড়ে দে।
Documents are also there, my lord.
My lord,
Wants to come back.
so far as the my lord, the child also, my lord, had to underwent an operation. My lord, the mother also underwent an operation. My lord, it's besides the point that the father neither not paid for anything. My lord, the mother's taking care, nothing done by the father. My lord, she's a housewife.
What do you do? Nothing.
She's a housewife.
You are educated, isn't it? Why are you not working?
My lord, those issues. I mean, educated. Yes, educated. My lord, only thing is, my lord, today, my lord, I am before one only short point. My lord, I'll not take more time. My lord, 5 minutes time, my lord, kindly grants me.
I am not going to look into the
My
judgment.
lord, I'll tell you, my lord, one judgment. That's it.
Nothing.
My lord, I'll tell you, lordship. My lord, I'll tell you, lordship. Then, my lord, let me argue on the point, my lord, because my lord, the categorically.
The regular court
My lord,
today. Nothing.
only thing is,
Please
my lord,
come.
only thing is, my lord, the mother should be given access to the child.
Yes.
My lord, the father is using the child as a leverage for settling matrimonial disputes. My lord, kindly not let it come between the mother and the child, my lord.
Petitioner claims to
my
be
lord,
the
one, my
mother
lord,
of an 8
my lord, may I
months
make
old
one submission?
child. Stop. Her allegation is that the private respondents, being her husband and parents-in-law, have forcefully driven her out from her matrimonial house, and has created a barrier between the mother and the child. Stop. The mother intends to breastfeed her child, which she is unable to do because she is not given any access to the child. Stop. Paragraph. The not the
Lord,
prayer
13th
has
I
been
visited.
made to
13th I
direct
visited,
the
nobody was there. The child was not there.
the made to direct the private respondents to hand over the custody of the child to the mother. Stop. Paragraph. Learned advocate representing the private respondents, has wakalatnama been filed?
In the morning,
Private respondent submits upon instruction that the petitioner voluntarily left her matrimonial house. Stop. There is a 498A proceeding pending before the learned trial court. Stop. It has been submitted that the petitioner is always welcome to return to her matrimonial home. Stop. Paragraph. As now the matter is taken up for consideration by this bench, as the same was mentioned for hearing on urgent basis. Stop. Prima facie, as it appears that the private respondents are willing to provide entry to the petitioner in the matrimonial house for the purpose of matrimonial house, it will be open for the petitioner to either visit the house or stay in her matrimonial house for the best interest of the child as well as for her own interest. Stop. Paragraph. Let the matter be placed before the regular bench on Monday.
My lord, one thing, my lord, let the mother be given access to the child. My lord, let the police, my lord.
You go. Why you want the
Something, my lord,
police?
only, my lord. My lord, the son is not there. Kindly sees, my lord, on page 33. I have mentioned we went there with the 2 police personnel. The child was not found. Police knows this. My lord, the police authorities knows this. They are not saying it. My lord, it was not there. My lord, I have mentioned. Kindly sees
I'll
page
check the
33 of my
line.
writ petition.
Take down one more line. It will be open for the petitioner to take the assistance of the police personnel in the event the petitioner is restrained from entering into her
Police is
matrimonial
always
home.
there to render ample assistance,
My
Lordship.
lord,
On the day
the
of recovery,
child is not there. My lord, his clothes, his
Kindly see
equipped,
page 2,
his
Lordship.
regular use,
Page 2, Lordship,
things,
page
nothing were there.
A report of the inspector in charge, Nagarbajar Police Station, signed on 17th of July 2026, filed in court, be written with the records.
Lordship.
My
Lordship,
lord,
police has
kindly, my lord, take records my submission that, my lord, we
Lordship,
went
may I
there
humbly
and the
submit the
child was
allegation
not there and
pertaining
police
to the
personnel
police
were also present. They also know that the child was not there in the
Lordship,
matrimonial home.
the police authority has
Order is here.
Yes,
In
yes.
case it is not there, you lodge a diary. Monday, the matter will appear before the regular bench. You can make submission. And I've
We have already lodged the complaint, my lord. They have not taken the diary. My lord, they have not taken it. Well, I have mentioned it in my page
inquiry
33.
is being done. It is there, and inquiry is being done. They have also
copy of the police
yes,
report.
Lordship.
Okay, here, let me have.
Lordship, police has 1 minute. Police has also communicated the issue to the subdivisional officer, Barashat, Barakpur, and to the child welfare committee.
All right,
Barashat.
you give a copy.
Yes.
The annexes are also there,
The
Lordship.
private respondent also to both parties. You have a copy with you?
No, Lordship.
Make a photocopy and give it.
I'll just hand over.
Monday, you can make all prayers.
Might be construed as to committing
Where is it mentioned? Is it mentioned? It is not mentioned.
Lordship,
Take down one line only. It is made clear that the court has not entered into any of the matrimonial disputes in between the parties and all points are left open.
My lord, today only, my lord, I
Any
want to go.
matrimonial
there
dispute,
is
the
a
police
declaration
My lord, I'll go. My lord, today evening I'll go. My lord, the
go.
son was not there on the last occasion on 13th.
You don't want the son. The child is a son.
Yes, ma'am.
All right. You go and see your child whether the is there or not. In case it is not there, you lodge a
Lordship, there is
complaint.
a declaration which has been made by the husband to the officer in charge of Nagarbajar police station that the child is with him, and because there was recovery of Sridhan articles, all the articles were thrown out, and since they were dust and the child may be affected
You
with
say
the allergy.
the child is there in the matrimonial home.
If they want
Take down one line also. It is the submission of the learned advocate for the private respondents that the child is in the matrimonial home of the petitioner.
Very well, my lord. I am most grateful. Yes. Yes.
them just intimate us because the father is also working, my lord, at least 1 hour prior intimation.
No. The mother will go to the house.
My lord, right now I'll go.
He's working, my lord. He's not at home at that moment, my lord.
He's here.
Oh, what is the reason?
No, because he's working. If he's
Let him work. Is he the father? He
Yes.
is working. He's
Yes.
working.
Leaves it to whom?
Where does he work?
Leaves the infant to whom?
It's a private limited company. Oh, what do you say? He's working. The mother can go and see the child. Where is the problem?
Well, right now, mother is willing to go, my lord. Right away. Right now.
Why? It is the mother who's going to breastfeed. What will the father do over there?
I'm just saying that prior intimation, at least 1 hour.
My lord, we are giving the intimation here and now. My lord, we'll go right now.
The mother will go now.
Right now.
There is a declaration also. The child is with him, Lordship. If that may be recorded, Lordship.
Right now, my lord, the mother will go.
There in your report?
Report, Lordship.
She can go now, my lord.
Yes.
Right away, my lord. Grateful. Grateful to your lordship.
Grateful, your Lordship.
My lord, I am for the petitioner, my lord. This was filed yesterday pursuant to the leave by this honorable court, my lord. Tomorrow, my lord, we are intending to, my lord, hold a public meeting. My lord, we made a representation before the, my lord, authority.
We have already permitted them. They have just introduced half-baked fat. We have told them that please do not do it at the junction. It's a public state highway. It's a taxi stand. 400 meters away, there is a field known as Velermat, where my lord, all the political meetings take place.
It was
He
not-
was verbally informed.
All right,
Yes,
please come.
Well,
The
in the
said
same
petition
field, my
has
lord,
been
previously
filed
meetings were
seeking
held, my lord.
permission for organizing public meeting on 18th
Velermat.
July 26 at 3 p.m.
Para 9, my lord,
18th
of the
July
report.
26 at 3 p.m. At, please take down this place. ঠিক আছে? Learned double AG submits double AG relying upon the instruction forwarded by the Inspector in Charge, Monteshwar Police Station, Purbo Bardhaman, signed on 16th of July 2026, submits that
এই যে দেখেন 9 আছে ফোনে বলে দিয়েছে তোমাকে বলেন তোমাকে
the police does not have any objection in principle to hold peaceful public meeting, provided the same is organized at a suitable venue where public safety, traffic management, and convenience are not adversely affected. Stop. The police does not have any objection and permission may be granted if the petitioner holds the proposed meeting at Usumgram Bhelermat, situated approximately 400 meters away from the originally proposed venue. Stop. The proposed venue is an open ground of adequate capacity where various political, social, cultural, and other non-political public programs have been organized on numerous occasions. The paragraph. As the request of the petitioner for granting permission has been allowed, however, with a shift in the venue of the meeting, it will be open for the petitioner to hold the meeting at the proposed venue in accordance with the instruction forwarded by the IC Monteshwar PS. Read petition disposed, service taken.
Subject to other permissions, my lord. This is the police permission.
The petitioner will be obliged to follow all other statutory formalities required for holding the meeting.
Extremely grateful.
Public meeting.
Extremely grateful.
Number 17.
Lordship, I am for the petitioner praying for short Passover, Lordship.
Why? Why Passover?
Engaged with court number 38.
Who is engaged?
Mr. Sono Ghosh, senior advocate.
Who?
Sono Ghosh.
Where is Abhipsha Sarkar? You do not know?
Achha. She had already chamber, but it's not that time. Yeah.
Yes.
I'm extremely sorry. Sorry,
The advocate on record is the chamber junior, so it's not available this time.
Why is she not available? She has left practice.
Don't know, Lordship.
Then, when you mention a matter, did you follow the list? Did you follow the list? Have you gone through the list? Are you aware there is a list?
Yes, Lordship. Kindly short Passover.
My lord, I am appearing for the petitioner. May I? In item number 17, my lord, I was appearing for the petitioner, my lord. I'm extremely sorry to appear on the virtual platform.
None appears on behalf of the petitioner.
But
Recommendation
item
sought,
number
dismissed.
17, I was appearing for the petitioner, my lord.
19 তো 21 তারিখে রয়েছে Item
I'm
20.
here for the petition, madam. I'm
Yes.
saying for not today.
Not today.
Yes.
Why?
No, no,
Yesterday the matter was taken up. Nobody was there. Today, not today. Why will it be adjourned?
but this matter led by Mr. Firdaus Shami. He's before court number 19. related
Right.
to a-
So call him. There are so many juniors.
Okay, then, ma'am, kindly make it pass over.
Yes.
But 21 also same.
21 also pass over. Call the advocate on record. The matter can proceed.
She's court number 13. Relating to
This is also a court where matters are being called. So somebody should be here. Next. 22.
Mr. Roy, appearing for SSC. I'm little Mr. Roy, appearing for SSC.
SSC. All right. Dismissed. Dismissed.
See, my lord, I am for
Oh, you are there.
No, this is, my lord, my application. These writ petitions have been filed by parents of some of the students in a school, my lord, where, my lord, the teachers have been transferred to the different schools due to, my lord, their transfer, my lord. There is no teacher at present for taking the subjects in this concerned school. We have made representations before the authorities concerned, my lord.
I did not follow. You are the
We are the parents of the students.
Parents of the students.
Students who are, my lord, studying in the relevant school, my lord, the
All
respondent
right.
schools.
Yes.
Some of
Respondent schools.
School.
How many?
No, my lord, in every writ petition, one school.
And who are the private respondents?
The private respondents are the teachers who to transfer from that school to other schools.
What is your right to move the writ petition?
My lord, the thing is, my lord, presently there is no teacher at all in the present school.
So
The
you sue
students
the district inspector of schools. Why are you suing the private respondents?
No, my lord,
Law permits them to be
because
transferred.
I have made a prayer, my lord, for retransfer them to the school.
Why?
That is why I have made them the. Otherwise,
Where is the service law?
My lord, there is no such law.
Why?
My lord,
How
it
is
is for
writ
the
petition
interest of the students at large, my lord. There are large number of students in the school who are studying.
The entire transfer policy, you are challenging it. Try to understand what your submission is.
I bow down, my lord. I bow down, my lord. Since I have made a specific prayer for retransfer of them, since there is no teacher has yet been available to the school, the subjects are not being, my lord, taught by the.
The petitioners claim to be the parents. In which class your ward studies?
My lord, in the higher secondaries, 11, 12.
The petitioners, Pradeep, what is this? The petitioners claim to be parents of students who are studying in a school. আচ্ছা স্কুলটার নাম লিখুন তো বাগমুন্ডি হাই স্কুল within bracket HS. Stop. They allege that the private respondents were serving as teachers in the subject school. Because of their transfer, there is no other teacher to teach the students. Stop. The petitioners pray for a direction upon the respondents to revert the teachers back to the school. Stop. Next. None appears on behalf of the private respondents. Stop.
No, my lord, I am for the private respondent.
Oh, you are there. Has Vakalatnama been filed?
Yes, ma'am.
You have filed it? What is your submission?
No, my lord, Mr. Chitopriya Ghosh is appearing.
Acha. Learned advocate representing the private respondents opposes the prayer of the petitioner. Stop. Upon hearing the submission made on behalf of both the parties, it appears that the private respondents have been transferred from the subject school following the transfer policy followed by the state. Not followed, prevailing in the state. Stop.
My lord, the transfers were made pursuant to the, my lord, application made by the, my lord, the teachers, my lord, on their medical ground.
Acha.
They have been transferred, but no one has been appointed in their, my lord. position, my lord, as of yet to the school.
Prevailing in the state stuff. The guardians of the wards hardly have a role to play in the matter of transfer of a subject teacher of a school. Stuff. The guardians may be aggrieved due to dearth of subject teachers. Stuff. The guardians ought to approach the district inspector of schools with their prayer for appointment of teachers in the schools so that the studies of the students do not hamper. Stop. The guardians do not have any right to pray for retransfer of the teachers who have already been transferred. Stop. Next, in view of the above, no relief can be granted to the petitioners in the instant writ petition. The writ petition fails and is thereby dismissed.
Only one, my lord, liberty may be given to approach the, my lord, concerned DI of the school.
I have already
My
mentioned.
lord, we should consider it, my lord, in a time.
The baby has not been born.
Pardon, my lord.
The baby has not been born.
No,
So direction
but I
cannot
have
be
made a representation, my lord. Page 42, your lordship will
You
kindly see
want
a demand
them to
notice
be
was
back. You want them to be back.
Yes, my lord. That
Then
is
that is something else.
in the event, my lord. If I
Sorry, sir.
made the representation,
You make, then non-consideration, the court is open.
how can I have to approach your lord?
You have to approach. How can the court stop you from approaching
They
the
are all, my
court?
lord, economic backward classes, my lord, belonging to, my lord, the weaker section of the economical, my lord.
Yes.
That is why that if that liberty may be given, my lord. Only
No,
one-
sorry. The item, this is item 23.
My lord, all are same.
All right. Schools are different.
Schools are different.
Schools will be different. Check up the name of the schools from each of the writ petition cost titles. 24, 25, 26, 27, 28, 29, 30.
32 months.
31, 32. What type of writ petition have you filed? How? Who advised?
Lord, I have been.
Under which provision of law did you advise?
I have told them to, my lord, pray for, my lord, transfer of some other to impose some other teachers into that school, but they insist for, my lord, retransfer of that teachers. my lord.
Very well. If they insist, and this is what the relief they get.
Lord, may I file the affidavit of?
Please do. Yes. And is the private respondent there in all the school? Are you there in all the matters? All matters? Is it in the same district? How is it?
It is within the same district, but teachers are different, my lord.
Teachers are different. And for some reason, all the teachers, parents have come to you and all the transfer teachers have gone to them. Yes. Passover matter, Dakun. Dakun.
Number 17.
Passover matter?
But I'm the petitioner, madam.
Yes.
So
Why are juniors sent to courts without proper training?
I'm extremely sorry. The advocate on record was probably busy somewhere. The advocate on record had sent somebody to seek an accommodation, madam. So the
The Learned Counsel mentioning doesn't know who the advocate on record is. Right? So, when you send a junior member, the junior member is always welcome. But at least they should be given a copy of the brief. They should know what is there. Should be able to open their mouth.
I bow down before your lordship.
And this is not the first time that court is telling this to you.
But I bow down to your lordship. The person who had done it is not briefed in the matter. She is briefed in the matter, madam.
Don't point fingers to anybody.
But she is briefed, madam.
Do not point fingers to
I'm
anybody.
extremely sorry. I should not have done that.
Yes, what is it?
This is a matter in which my transfer application has been rejected, madam. I'm challenging
ground?
On the ground that there are many seniors in my school who have applied for the transfer, and they have to be given preference first. Probably
Obviously,
the only thing is that I have got
your
that,
application was in 21
my lord.
and rejected in 21. HOI to applicant.
Rejected.
Please take down.
The only thing may I point out, my lord, the reasons which have been given for my transfer, probably subject to correction, my lord. This has to be considered whether my grounds and the grounds of the senior teachers, if there are any, at least the names have not been disclosed, if their ground is as compelling as that of my ground, my lord.
What is your ground?
For two grounds, my lord. Firstly, the distance. Secondly, my husband suffers from heart disease, my lord.
Very good.
And both the grounds are part of the rules, my lord.
The petitioner is aggrieved as not her application. Is it his or her?
Her, my lord.
Her.
My lord.
Yes, as her application seeking transfers to rejected by the authority. Stop paragraph. It appears that the rejection was made in the year 2021. Stop. Considerable period of time has elapsed, and there may be change in the circumstances. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply a fresh seeking transfer, disclosing grounds for the same. S will be in brackets.
The only thing, the portal is now closed, my lord.
The portal will open very soon. In fact, it is open. It is non-functional, and by next week it will be open. 20.
Lord, kindly apologize, my Lord.
I cannot hear you.
Kindly apologize, my Lord. The argument also been going on. That's why not
Still going on?
Yes, my Lord.
Not today.
My Lord,
21 also not
Lord,
today.
if it makes it not today, that it will come on Monday. There is some difficulty on 21st to 23rd. Kindly make it after 23rd.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. List on 3rd of August.
Item 20.
20 and 21.
No, 21 we are for the commission.
Not same prayer.
Petitioner, you're for the commission. Record your appearance, please. And 21 are there?
No, that I haven't.
Somebody else must be there, whoever it is. Yes. Item 10. Item 10. Where is Mr. Bari? He was supposed to come.
Yes.
Prior to rising. No?
Your Lordship, item number 10, Mr. HON'BLE is appearing for the petitioner.
Yes.
He is engaged in court number 4. He is coming, Your Lordship.
All right, call the other matters. Motion 1 transfer. Further action 454. Dismissed.
My lord, I am for the petitioner. My lord, this is offline transfer application. Ground is, my lord, petitioner is suffering by blood cancer. Now, my lord, offline school already issued the NOC and relegated the matter to the DI. However, due to suspension of portal, the DI has not taken any steps.
Since when?
My lord, it is 2026. My lord, kindly see page number 44. It has forwarded to the DI by the head of the institution.
Regarding application.
It has NOC has already given, my lord. Page 41 is the NOC petition.
All right. So right now it is before the DI.
Yes, it is DI.
Self-medical or what?
Self-medical ground. It a forward.
All right. Disposed.
Grateful.
Self-medical ground. Service is taken on record. It has been dismissed. Dekhi file ta. 454.
Transfer application pending at the DI. School has given no objection and forwarded to the DI.
Since when?
The
Not an application.
yes.
So who is for the commission?
With no objection certificate.
Has been forwarded. Either the civil order.
Kindly check whether the commission has been served or not.
Not served.
Commission কি করবে?
Commission is a party.
And rule is of the commission.
So what?
Commission not served. Check up your service. There is the affidavit of service. Check up.
Yes, yes. Commission has been served.
Check.
Yes.
Hey, commission has been served.
Okay,
Where is
my
the
lord,
track report?
11 March.
Track
That has
report
been
is-
speed post, right? Obviously, this has been served. Commission has nothing to do now.
It's pending before the DI.
Pending before the DI.
Page 50.
Page.
And what is the ground of transfer?
General ground.
All right.
Page 50.
DI.
পরেরটা দাও।
Disposed.
পরেরটা দাও, যা।
Service on record.
This is also same.
455 টা করতে দিন, এটা 456.
456 আমার।
যাও, যাও।
I put that taken. Petition, my
যাও, যাও।
lord. Petition's application, my lords, were rejected by the school authority, my lord, on the ground of the shortage of teacher and my
When?
My lord, page 51, my lord. Earlier round of litigation, your lordship directed the school authority to consider my representation, my lord. While considering the representation, my lord, the instant application made, transfer application made on the ground of medical, my lord. The school, my lord, without examining the medical.
Who's medical? Self?
My lord, without examining the medical, my lord, the school rejected, my lord, on the ground of two.
Rejection is page 51.
51, my lord. Shortage of teacher and my lord.
Matter relates to the transfer as detailed. Yeah, excessive regarding the acute shortage
Not
of
medically
teaching staff.
Let the DI, my lord, be medically examined, my lord, if it is found.
Single subject teacher of geography.
Yes, ma'am.
Single subject teacher.
Can you set
Self
aside,
medical ground.
can you set aside the order of the school, my lord?
This is set aside.
My lord.
Page 51 is set aside.
Wait a minute.
My lord, I am for the petitioner. My lord, it is a school is a zero enrollment school. My transfer application pending before the commission. Now, my lord, ground is, my lord, is a medical ground. However, the school is the running.
Medical.
My lord, self-medical.
Page 28, my lord, pending since 2020.
My lord, it is a
20.
two.
And it is still zero enrollment.
But I have annexed the document, page 27. I have written to the authority, maybe I may be placed in the other place to to discharge my official duty. However, it is pending. Since, my lord, it has been observed in
Page
several
28.
occasions. My lord is straightway DI. My lord, since it has forwarded to the commission, let the commission be directed to, since a zero enrollment student, I am sitting idle here. Page 27 is my prayer.
Acha, pending before the commission. Zero enrollment school.
Stop.
Commission will consider.
He is only
person running. Madam, page 20. Kindly see the
page 26.
Just imagine. No student, no teacher, and you are
No
getting
management.
money. So happy life.
No, but I am voluntarily saying.
And what is happening to the students?
Happening to the school. Who will open the keys?
Number of schools. My
Number of
item number 491, no student, only one teacher. This is the
Who is for the state? Madam, please take note of all these schools. Right?
And issue transfer order under article section 10B. Administrative transfer.
Mr. Bhattacharya, since you are here, such a tall figure, I cannot miss you. We are handling with schools where there is no teacher. Only one teacher is there to open the lock and to close it, and no students also. And the teacher seeks transfer on medical ground. What is going to happen to the school? There will be no one to open it also. And this is not a single school. There are several schools, absolutely zero enrollment. The teachers sitting back do not know where, earning money every month.
Today I have just read a newspaper reporting that government has taken into consideration and decided to issue a guidelines for the schools wherein either no teacher or no student. So
whatever, this has come to the notice of the court, and this is not for the first time. Earlier determination also, I saw the same thing. Since you are here, I just mentioned it to you. Take reformative steps.
Yes,
This is
possibly
only-
it has done. It is under processing. SOP has. Yes.
Very well. Yeah, and this is not, you are there from 22 till 26. Imagine. Call the next matter, please.
Great. 458, my lord, time for the petition.
Same?
No.
Are you teaching?
Yes, I am teaching, my lord. It is there, my lord. My lord, it is a distance ground transfer application. Single teacher, it is pending before the DI for a considerable period, my lord. My lord, it has been observed by the head of the institution.
Date, since when is it
My
pending?
lord, page 22. But
21st of September
2022, but it is a single teacher. It has been observed by the school authority. It is a single teacher. It is pending before the DI.
But, and still now there is no teacher?
No, teacher is there, but my subject
single subject teacher?
I have
Still
stated,
now?
yes, I have stated in my application also. So, my lord, let the DI be decided in terms of Gokul Mullik and Rupa.
Single subject teacher.
Grateful.
DI.
Grateful.
Madam, I am for the petitioner.
And I am for the
This is also pending before the DI of schools. Page 37.
Three seven.
37.
What is the ground for transfer?
General transfer.
General transfer and
Distance ground.
37. DI will consider.
The orderটা দেন ঋতব্রত order. দুটোই
But
বিভক্ত service.
I am for the petitioner.
চারটে copy
It is medical ground transfer, self medical ground pending before the DI. Page 19 is my transfer application. It is a self medical ground, serious problem observed by the school authority and pending before the DI. No medical verification has done yet.
What is the date?
My lord, date is 2020, 12th September 2022. It has forwarded to the DI, but no medical has done yet.
Then make fresh application.
So pending before the DI, my lord, ultimately CMO has to done by medical examination. So,
CMO stage is before the School.
No, BMOH is subject to correction. BMOH is the school. CMOH is the ultimate authority to decide.
Yes.
So it is pending, no medical verification yet has done, my lord. So let the DI conducted medical verification since my lord's order is there. If the medical verification justified in my transfer, then it will forward to the commission.
You say it's pending before the DI, page 50.
19, my lord, 19. 12th September 2022, it has forwarded to the school to DI. না না লাস্ট ক্লাস যখন উঠছি স্ট্যাটাসটা এটা হ্যাঁ
A serious problem.
হ্যাঁ
All right, DI will consider.
grateful.
61 million, I am for the commission.
Page 39, my lord, this is also pending before the DI of schools. General ground, my lord,
Page
39. এই দেখুন, দুটো করে এভিডেন্স সার্ভিস, দুটো করে এভিডেন্স সার্ভিস।
Downloaded from the search and take a print out.
চারবার করে কপি সার্চ করেছি।
Pending before the DI.
Pending before the
My lord, I am for the petition in this matter. My lord, petitioner was a single subject teacher. Then she was rejected. Then a writ application was filed. The Honorable Single Bench was pleased to pass order under 3rd January 2022, but put a rider that willing teacher is to be arranged. Now that was challenged before the Honorable Division Bench. Honorable Division Bench clarified that willing teacher is not a concept. Then, my lord, it was sent to the DI to take a step. Now, my lord, kindly come to page 119. That is the last development. Kindly see the DI has again gone back to the willing teacher concept. Kindly take the last line. If your opinion is in affirmative, then send also the letter of consent from your end and also teacher consent immediately. Again, the consent of that willingness of the teacher was sought for, which was deprecated by the Honorable Division Bench in its order. একই পেজ, দুটো একই পেজ, দুবার চলে গেছে। Kindly take page
Who's
116.
for the state?
State.
single teacher.
Single teacher. Page 116 is the observation. Kindly take the observation of the Honorable Division Bench for once. Page 116, second paragraph onwards. In
Page 119 and 120 is the
same, my lord, wrongly 2 pages. Same page, my lord, same page. 116, kindly take, my lord, the second paragraph. In the said notification, there is no rider that the DISC has to make any endeavor to find out any willing teacher of neighboring school who can man the post of the applicant temporarily till the regular incumbent joins the post. The term willing does not feature in the said notification. The competent authority took a conscious decision towards amendment of the 2015 rules. So, my lord, this has to go. In the
page 119 is set aside and single subject teacher order is going to come.
And my lord, that observation that your lordship yesterday made, this Amitabh Pal is to be.
Guidelines of the government.
Yes, yes.
To deal with that.
Yes, yes, that way I'm seeking.
Why is the DI not acting in
Yes.
accordance with the same?
My lord, this order, your lordship's order.
This order, just now I.
No. My lord, this order, this observation is there, my lord.
Kindly see the order, kindly see.
Sure.
In terms of the notification, it is once well memorials, once because that Biani Chakraborty matter, the normal section of Majority has applied to the single teacher and single subject. According to the extent rule, local temporary arrangement of review of the same subject from nearby schools who will take classes in places of affiliates during is essential. From available record your schools have been identified as the available nearby schools, and hence you being the head of the institution, the same is a requested to state whether the teacher with same subject, same section be available. The school authority has to give the answer.
No, that willing.
Suppose the school is unable to get hold of a teacher who can teach. What is going to happen? Will the applicant who applies for transfer, the application be kept pending? That is not the law. Law is that
No. Circular has been explained. Division bench has clarified.
going from to submission. All right.
My lord,
There are division benches order.
order আছে division.
All right.
দি। My lord, the Amitabh Gopal's observation may be recorded. That irrespective of the fact, my lord, the alternative arrangement that may be there. I'm grateful.
463 is the last matter from the monthly list.
463. I am for the petitioner, my lord. Here also, এই আগেরটা advocate on এটা নিয়ে affidavit service. My lord, same issue. Again, it had happened. Here also, my lord, there is a division bench order. My lord, regarding 3rd January, kindly come to page 106, second paragraph. That is willing teacher again. Same issue, willing teacher. Now, my lord, kindly see. It's same.
All right. Give him a copy of the orders passed
Orders
in
passed. My
Rupak
lord,
Dua and
yes, I'm giving right now.
and the
My
Amitabh
lord, this order, may I just say one thing? Next page, the DI writes willing teacher despite there is an observation of the division bench.
Give a copy to Mr. Bhattacharya.
Monday, my lord, calendar.
Yes, only not today.
Only not today. এই যে
Passover matter, Mr. Bari's matter.
আরে এটা সেটেল হয়ে গেছে এই জাজমেন্ট আমি দিয়ে দিলাম আই হ্যাভ হ্যান্ডেড ওভার আ কপি রিটের কপি দেবো আপনাকে আজকে দিয়ে দিচ্ছি জেরক্স করে
Item number 10, Passover matter.
দিয়ে দিচ্ছি আপনাকে তোমাকে দিয়ে দেবো
Malat, I have a talk with the petitioner, Malat. The presently, Malat, the petitioner's physical condition is such that she cannot walk freely. Malat, it looks like the she is a handicapped lady. The doctor advised unless she took precaution, then her both leg will be paralyzed. She has also the problem of sleep disk, C3 and C4 problem. She is also suffering from.
Then she cannot teach.
Now, Malat,
She is such a sick teacher cannot be permitted.
present school, Malat,
Very sorry.
Malat, let it be considered in terms of that. Malat, only Malat, that.
What is to be considered?
Malat, that page 83, that letter that has not been considered by the Commissioner of School, let it be considered. Malat, only that prayer, Malat, kindly, Malat, page 83. Let it be considered.
Jeff, please come. The petitioner alleges that she is being posted at a school which is very far off from her residence. Stop. In view of her health condition, she is not in a position to attend the school on regular basis. Stop. The request of the petitioner was request of the petitioner for posting her at a school nearby to her residence was forwarded by the Secretary of the West Bengal Central School Service Commission to the Commissioner of School Education by a communicating letter dated 28th of April 2026. Stop. The same is alleged to be kept pending. Paragraph without entering into the merit of the claim of the petitioner, as it appears that a request from the Secretary of the Commission is pending before the Commissioner of School Education, the instant writ petition stands disposed of by directing the Commissioner of School Education to consider the request of the petitioner in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The fate of the petitioner's application shall be made known to her immediately thereafter.
কাটুনির ফল পেলে 3টে কোট ঘুরে
ঘুরে জলটা খেলে আমি ওকে প্রথম দিন বললাম কনসিডারে মামলা বলিনি প্রথম দিন তোকে বল দাদা আপনার 3টে ফিস হলো 3টে না 2টো হলো কেন 2টো 3টে হয়েছে 2টো থেকে তবে হেয়ারিং দেখবে না 3টে হলো আগে 3 আছে
না এই ম্যাটারটা কতগুলো লেখা ম্যাটারটা তো সেই হিরণময়ের কোটে হলো না দুদিন আমি আবার কবে বড় লোক
আমার মতো হতে পারবি এত লম্বা তুই হবি না কিচ্ছু পড়ে
আমার খালি বড় লোক হওয়ার বদনামটা আছে টাকা পাইলে কি
স্যার এই মান্থলি লিস্টের সিরিয়ালটা আর হবে তো চলবে হিয়ারিং দেখে নিই কি তাও একবার হ্যাঁ হ্যাঁ টু পিএম 4 দিনকে আছে
আর ওর এলাও কি সাইকেলটা আছে মানে অফিসে কটা আছে এখানেই আছে না বলুন ডব্লিউবিসি আছে 45 তারপরে 8981 তারপরে হচ্ছে 334 এই গাড়ি কত না ওই বলে আসতে হবে না গাড়িটা বন্ধ করুন এই বান্ডিলটা আমি এখানে তুলে দিচ্ছি অটোমেটিক্যালি এটাকে সরিয়ে দিলাম এই সরিয়ে দিয়েছি না আচ্ছা ঠিক মানটা তুলে দিলাম সাজানো হয়ে গেল। আমি বান্ডিলটা আজকে আছে হ্যাঁ এইখানে তুলে দিলাম এই বান্ডিল বলা শুধু সরিয়ে দিন তো ট্রান্সফারটা হয়ে গেলে মাপ দিয়ে দাও আমাদের
Ordinary matters from the heading list, item number 33.
Are you the petitioner in item 33? Are you the petitioner?
33, 34.
আজকে শৈলেশ আসেনি? Yes.
observed on the last occasion regarding the impugned notice and the illegal disconnection. My lady, before that, kindly sees I have also filed an application, Can 1 of 2026, for modification of your ladyship's order. My lady,
What is the modification that you are seeking?
my lady, kindly sees the order dated 22nd May 2026. The second para. May I read?
Yes.
The petitioner is enjoying electricity, but the connection was disconnected in the month of March. Second, your lady, they got access for meter reading and for meter inspection. That is evident from the report. But in that, they have said, in the order itself, it says the lady officer who accompanied the other officers of WBSEDCL at the time of inspection was also not permitted to enter the premises. But she has entered. She did the inspection. And your ladyship, regarding the fourth point, despite order passed by the court for providing access, the officers of WBSEDCL were allegedly detained for more than 1.5 hours at the gate. The officers were compelled to lodge complaint before the inspector in charge Bhatpara police station, and the daughter of the petitioner, who is conducting advocate, refused to sign the inspection report. The report was not made in front of the advocate. And your ladyship, that adverse observation, I'm kindly praying before your
Which
ladyship.
adverse observation?
The seventh point, it does not appear that the petitioner is inclined to resolve the issue.
Yes.
On the contrary, it appears that she's trying to complicate the matter.
Yes.
That I'm praying to expunge the same, my
Will
lady.
it help you? Will it help you?
My lady, because these observations can go against me, because I have filed also a complaint before the consumer forum
Yes.
for trial and all, because
Yes.
their notice has to be adjudicated on the facts, my lady. That's because I have filed this application, and in 19th May order also, access to the meter for taking meter reading is not provided. But it is evident from the report they have done the inspection. At first they raised the spot bill, and after this they are doing like this, that we are not providing access. After your ladyship's order also, they entered the premises. They did the whole inspection, but after this they are saying that they have misbehaved with, but that is wrong. We are denying such, and that has to be proved by the facts, because they raised the complaint only after going from the premises. That is afterthought, and that has to be adjudicated by fair trial.
Where?
My lady, I have filed one consumer complaint that I have stated in my application.
That is different.
That is
different. There is a police case pending.
No police case. Only a
complaint has been lodged.
Complaint
Now
has
they
been
will
lodged.
initiate
I have
a
also
police-
I have also lodged a complaint.
All right, so you go before the criminal court and get it done.
Yes, my lady. That is, I'm saying that they are saying that they have been misbehaved with, but that is wrong. They were not misbehaved. Why 1.5 hours time taken by them, or 1 hour? Because of the reconnection. They did the reconnection. Entered inside.
It doesn't matter. I do not want to hear all these things. What is the would you like to place the modification application or the writ petition, whatever you choose?
Your ladyship, kindly take both of it, because it is urgent, because the petitioner is very ill, and
Yes.
I'm praying for urgent reconnection of the electricity.
Yes, place your case.
My lady, kindly sees the scope of this writ petition is very limited, as I have already shown you the order of the Honorable Division Bench of Justice Shompa Sarkar, where Justice Sarkar has divided the matter into two parts. That if you are my lady, that order has not been annexed here. May I kindly hand over?
You are relying upon an order, you not annexed it.
My lady, that order was not annexed in the writ petition. I have given.
What is the date of the order?
It's 31st. It's 31st of March.
Then the writ petition was
Yes,
affirmed on
my
the
lady, it has been annexed in their report.
Yes, please
It
show.
has been annexed in their report.
Please show.
My lady, kindly the last page of the order.
No, it's annexed in the report. Then show it from the report. Don't hand over documents over the counter.
I'm showing.
It is 19th of March, I can see one order, and 31st of March.
Yes, my lady.
Yes.
That is. It is annexed with the report dated 4th May. My lady kindly sees the last page of the order where her ladyship has categorically stated that with regard to the my lady, page 2 of the order, page 2 of the order, the last para, the last 3 lines. With regard to the allegation of disconnection of supply, the same was not the subject matter of the writ petition. The issue is open to be decided at an appropriate stage if the appellant files further proceeding alleging wrongful disconnection. And that I have alleged here. That is the only scope of this writ petition, my lady. My lady kindly sees point 4. Under such circumstances, we are not inclined to entertain the appeal. The submission of Ms. Saul Leonard, advocate for the appellant, that she could not appear physically and certain important facts could not brought on record is a ground for review. And as such, the appellant is at liberty to prefer a review before his lordship, and that is Honorable Justice Ravi Kishan Kapoor. And that is the review application I have filed. May I kindly
Keep it with you. The court is not concerned with the review.
Yeah, that I'm saying, that review has been filed.
Doesn't matter.
That
You
portion-
file, you do not file, it's your wish.
As you. My lady kindly sees the impugned notice. I'm coming directly to
No, doesn't matter. The court is not concerned with the review. What is there in the writ petition, you please place.
my lady. Kindly sees
Please place.
Kindly sees the writ petition. My writ petition filed here, which is page 53. The notice is appearing.
Yes.
Here, my lady, they have shown. There are 2 notices. One. May take 1 minute. My lady kindly says page 53 of my writ petition here. May I read?
Yes.
In pursuance to the order dated to Meera Sahu, present user, Mathura Sahu Jaiswal, deceased, 23 West Gospara Road. In pursuance to the order dated 20th March 2026, passed by the learned High Court at Calcutta in WPA number 5357 of 2026, the undersigned and other officials went to inspect the meter bearing such and such at the premises of Mathura Sahu Jaiswal, deceased, present user Meera Sahu, 23 of such and such address bearing consumer ID number such and such on 23rd March 2026 at about 11:45 a.m. WBCDCL official along with the officers and forces of Bhatpara police station also went to inspect the premises on 13th March 2026 as per direction of learned High Court order dated 9th March, but in both the times they did not give access to the said premises as per Indian Electricity Act 2003 and as amended till date under section 163 and under regulation of WBERC 55 clause 8.1, 8.1.2. As such, WBSCDCL official along with SNLP 24 Parganas North Wings with forces of Bhatpara police station disconnect the service line on 23rd March at 11:45 a.m. from the nearest pole of WBSCDCL, finding no other alternative. And my lady, the page 54 is the another notice. That is the same notice, but in the format that they went for the inspection, but they could not find anyone, door locked. That's why they disconnected the supply. Your ladyship kindly sees date 23rd March. I'm reading from page 54. Date 23rd March 2026. Time 11:45 hours. What is the purpose? Inspection. The box inspection has been ticked out. Door locked from inside, not found. My lady. And my lady, they have stated that they have done this as per the order dated 20th March 2026. Now, my lady, may I kindly place the order dated 20th March 2026? On such and such date, they only got the liberty to take actions as per section 163 of the Electricity Act.
Where is that order? 20. Do not hand over copies. Where is that order? 20th of March.
My lady, it is the subject matter of the review application. That's why this order has been annexed there only. My lady, may I kindly hand over one copy?
No, I will not look at any document if you hand over in this way. This notice mentions about 20th March.
20th March.
You should have annexed it.
My lady, that was the, I'm sorry, I thought that was the subject matter of review. That's why I'm not annexed.
The court doesn't want to enter into that, but the court wants to see what is there because this order is in response to 20th of March. Will you not annex?
And my lady, that report copy has been annexed with this report.
Yes, then show it from the report, the copy of the order, 20th of March. Yes, it is there in the report.
The order dated 20th.
Yes, it's there.
My lady, kindly sees the second page. That is the relevant paragraph. The last paragraph. Liberty is granted to the WBSEDCL to exercise all powers available, both civil and criminal, as well as under section 163 of the Electricity Act 2003. Why, my lady? Because they stated they have filed a report that I have not allowed the inspection, but that is wrong because they tried to frame me, and that's why I filed the review.
Now tell me one thing. This 20th March 26 is under review?
Yes, my lady.
The impugned order is relying upon 20th March. You get the order reviewed and then come back. If this order is reviewed, the order impugned, nothing will remain. That will go. Then you go to the review court, get it reviewed and come back.
But my lady, the Honorable Division Bench has said that illegal disconnection is a different issue because the matter was dismissed on 20th March.
Yes.
And the disconnection happened on 23rd March.
Yes.
That's
23rd March disconnection is relying upon the 20th March's
but
order.
That is wrong. But that is wrong.
That is wrong. You go and set it right by the review court.
That is another issue, my lady. That is pending before the review court.
Then do not mention anything about review over here. You, page 53 is impugned. You mention about page 53 only.
Page 53, page 54?
Yes.
And review also I have mentioned in my application. And exception also. I have mentioned this. But my lady, kindly sees, as per section 163, they tried to get access for the inspection of that meter only. And after inspection also, they have disconnected the supply, and that is wrong. May I kindly place section 163 of the Electricity
Yes, please
Act?
show.
Section 163. My lady, section 163 of the Electricity Act, may I kindly read the relevant portion? May I kindly read?
Yes.
My lady, it is section 163, power of licensee to enter premises and to remove fittings or other apparatus of licensees. A licensee or any other person duly authorized by licensee license may at any reasonable time and on informing the occupier of his intention enter any premises to which electricity is or has been supplied by him, of any premises or land under, over, along, across, in or upon which the electricity supply lines or other works have been lawfully placed by him for the purpose of inspecting, and that is my case, inspection. Testing and other things are there. And my lady, kindly sees second point. A licensee or any person authorized as aforesaid may also, in pursuance of a special order in this behalf made by an executive magistrate, and after giving not less than 24 hours notice in writing to the occupier, enter any premises or land referred to in subsection 1 for any of the purpose mentioned therein above. My lady, kindly sees point the third paragraph, where where a consumer refuses to allow a licensee or any person authorized as aforesaid to enter his premises or land in pursuance of the provision of subsection 1 or subsection 2, when such licensee or person has so entered, refuses to allow him to perform any act, that is inspection, which he is authorized by those subsections to perform, or fails to give reasonable facilities for such entry or performance, the licensee may, after expiry of 24 hours from the service of a notice in writing on the consumer, cut off the supply to the consumer for so long as such refusal or failure continues, but for no longer. My lady, they did the inspection on 20th May after the order of my ladyship. They did the inspection after reconnection and then they disconnected.
This is afterwards. The notice, impugned notice, 163 notice is given because you did not allow the authority to inspect.
I deny this, my lady, because this section also says,
deny?
My lady, this section also
You deny?
Yes.
The writ petition will not be maintainable?
No, my lady, I am denying their contention that I have not
Yes,
allowed.
that is a disputed question of fact.
My lady, kindly see section 163 says two things. That first, before entering any premises, you have to give 24-hour notice so that the consumer could know that you are coming. And before disconnection also, you have to serve 24 hours notice, at least 24 hours notice. And in both the cases, they are not complied with. That's why the connection, the disconnection was illegal, done illegally. On the basis of that order, because that order has granted only liberty. That is evident from the order, my lady. But if they want to do any action, they want to take any action, they have to serve two notice. First, that I am coming, 24-hour prior notice, and after that, 24-hour notice that you have not allowed me for inspection. That's why I would disconnect the same, so that the consumer could get the time to reply or to give access or something. And what they did, they attacked the petitioner. They took signature of the persons, outsiders, who are in the enmity with the petitioner for so long, and we have filed also complaint. That's why I'm saying, my lady, that that notice, earlier notice, has to be seen along with that issue, so that that point has to be decided by a fair trial, by the trial court only. And that's why I filed a consumer complaint, and that I have stated in my application. But this disconnection, my lady, is totally illegal, because at first, before coming also, they have not given notice, and before disconnection also, they have not given notice.
All right. Yes.
And my lady, I have paid the bill till June 2026.
So that is not the issue.
They have raised the bill.
Payment is not the issue.
Payment is not the issue, but I have
Or non giving access is the issue.
Yes, my lady. That is kindly obliged.
Yes.
May I? But there are basically three issues which I have already specified before, Your Lordship. May I recanvass the issue? First, we could not get access to the meter board. Second point is that the petitioner before Your Lordship is not our registered consumer till date. And third point, since we are not getting access to the meter board, we have given the inspection report on that is on 22nd of May before Your Lordship. I will place that. On that basis, as per the provision of law, the distribution company can shift the meter to a place where they can get easy access to the meter board. But so far, the first point is concerned.
Non-giving notice.
Non-giving notice. If Your Lordship kindly come to page 152, page 52 of the writ petition.
Yes.
My absolutely misrepresentation before Lordship, kindly come to page 52. Now, when the notice has been given. That is on 23rd of February 2026. What has been written? Make an arrangement to make meter reading and replacement of meter.
with reference to your letter dated such and such, which was received to this end on 16/2/2020, this is to inform you that the bill was generated on account of door lock of your premises and which is done as per WBRC norms. Details of your previous bill record as tabulated. I will show from the other department record also, which is a door lock, because on the last occasion, it has been specified by your lordship that since they have made an transfer applications, which has been acknowledged, whether we have intimated to them. I will show that we have already intimated to them, but it has been door locked in several occasions. The letter has been given on 22nd of June 2026, and subsequently the peon has made all endeavor to search them and to give this. One time it was several times door locked, then it was unclaimed, then subsequently it was returned to us. I will show from the record, I will give it. But prior to that, may I kindly see, this is the notice which has been given in February. What has been specified? This is a bill. Now kindly come to paragraph 1 onwards. It is learned from the meter reader and revealed from the above bill record that you do not cooperate with the taking meter reading, which is estimated bill was generated as per norms of such and such clause. You allow our meter reader personnel to check the meter. If you have any problem to check the meter reading, you may apply for shifting of the same. That has also been given. It is to be noted here that you are enjoying electricity in the name of Mothurasa, who is deceased. No application of such name change has been made. You are requested to apply for the same. So it is not now. From that time onwards, that is from 23rd February, it has been given. One letter was served you through post regarding replacement of conventional meters such as are not allowed to replace the meter till date, and such as hence you are once again requested to make and to take meter reading as well as to replace the existing hybrid meter. But that has been given. We have been disconnected at that point of time. No. They have filed a I haven't disturbed you. Now they have filed a writ petition. In the writ petition, the Honorable Court was pleased to direct us to make an inspection. The matter has been kept pending. What they have done, against that order, they have preferred an appeal. And that appeal was dismissed. Subsequently, again this matter was been taken up by this single bench, and your lordship will see that order passed on 17th of March 2026, where this lordship was pleased to direct us to take steps as per under section 163 as well as civil and criminal. Against that, they have preferred an appeal. The Honorable Court has not set aside that order. Even there is a finding that under section 163 that can be done. Till date, that order has been sustained at that phase. They haven't challenged that order. Now they have taken up, they have filed the subsequent writ petition, and his lordship was pleased to release the matter because they are not trying to resolve the issue. This matter was placed before your lordship. On 19th of May, his lordship was pleased to take this matter, and your lordship was directed us to make an inspection. Your lordship, kindly take the report for a moment. Detailed report. That is the report dated 20th May 2026. Nothing has been contradicted pertaining to the provision of this. Now kindly come this in this report. May I place it? That is the report dated 20 May 2020. Lordship got that? As per order of Honorable High Court, I such and such and other following official Kakinada go to this inspect the meter at 23 Kakinada at such and such place, and name of the officials has been given. Prior intimation, even prior to that, they are saying that no intimation has been given. I have given the prior intimation regarding inspection has been sent through mail to such and such advocate on 19/5/2026. I have annexed that. I have already annexed those documents.
My lady, but the disconnection was happening in March.
Please wait. Why are you disturbing him?
I'm sorry, but disconnection happened.
Why don't you take your seat? Yes.
They initially opposed to give entry intentionally, which they are accustomed and have been doing such activity such long time and can dispatch order of the Honorable.
This I have seen.
Yes, and on that basis we have got the video, but I am not putting court to embarrass on the situation. Now letter 3 personnel are allowed. Now on that basis, lordship kindly see the certain provision has been given in this report. I will show one after another. Such type of now now meter number such and such guarantee, this is the obsolete meter. Your lordship knows that there is a old meter is there, and we want to replace the meter in a new static meter, lordship. So ST meter it is called. Now this has been specified there, and now kindly see meter has losses effective does not have to such and such expired and guarantee which has been on, it has already expired on July 2007. It is to be replaced immediately as per regulation. Now I have annexed the regulation. Kindly see the annexure, that is annexure C. This is the regulation, page 5, lordship.
Yes.
In this regulation, we will find, lordship, that is regulation 50, clause number 16. That is at page 6. Lordship got that?
Yes.
For regulation 11, the principal the following regulation shall be substituted. This has been amendment. I have also given the previous regulation as an amendment also. Replacement of meter, if required within 10 days from the date of receipt of complaint, no complaint, or detection by the licensee. I am asserting on that. So licensee has got the full liberty to replace the meter as per the statutory provisions. Now, lordship, kindly come to the next part, that is regulation 46, starting from page 7, lordship.
Yes.
It was initially there. That was the same thing is there. It was the time period was 7 days, and subsequently it has been by way of amendment has been enhanced to 10 days, lordship. So this is the period where the licensee has been granted 2 aspects. One, complaint if is lost. If no complaint lodged, if the licensee find that is the meter is to be replaced, they have got the full domain. On that basis, it has been replaced. It can be replaced. Now, lordship, kindly come. The second point, that is 4 Roman 2 in my report.
Yes.
Meters need to be shifted to a reasonable place, location outside of their room, which has been shown to them so that we can get access to the meter with a hassle-free to take proper reading as well as to raise proper billing as per regulation. Now, kindly see annexure F, that is, I will draw your lordship, that is the meter reading where we can give the, we have given the photograph also there where we can replace that meter so that there cannot be any danger. There are no, we should not invade their privacy. We can go there and can take meter reading. We cannot go at their own sweet will that will.
And nobody, no third person will be in a position to tamper the meter or
No,
enjoy
there is no chance. So on that basis, your lordship, the meter should be in a covered place, lordship. There will be no issue on that.
No issue.
No issue. Now, lordship, kindly come to the annexure F. Why I am saying, because as per regulations, we should get free access to the meter board. But unfortunately, there are several problems. The door are locked, and in several occasions, we are registered. We could not access to the meter board. Now, kindly come to regulation 55. I am drawing your lordship kind attention to certain clause. Clause 8.1.
Which page I get it?
I'm starting from page 10, lordship. Lordship got that? Page 10 is the regulation 55. Now, lordship, kindly turn to page 11. That is, starting heading is access to the premises of consumer. Lordship got that? Which we are not getting. The access for delivery of bill, reading of meter, testing, repairing, altering the supply license field, validation for prepaid meter, etc. So we should get access. Then 8.1.1, the employee licensee or anyone acting on behalf of the licensee shall have access to the premises of a consumer at any reasonable time for the purpose of delivery of bill, reading of meters, validation for prepaid, that is so reading of meter, testing, we should get access, free access to the meter board. We cannot be registered as per clause 8.1.1. As well as, your lordship, can you see 8.1.2? Subject to the applicable provision of these regulations, the licensee shall also have the power to enter the premises for the purpose of examining, testing the electric supply line, meter, and also for the purpose of reviewing in terms of section 163. So, my humble submission before your lordship, we have got the authority to get access to the meter board. We have got the authority to, if we do not get access to the meter board, we have got the authority to disconnect that meter. Even the Honorable Court has given the sanctity, that is the order passed on 17/3/2026. Even the appeal court never interfere on such order. So far, they never said that to restore that connection. Appeal court says you challenge in accordance with law. Now, your lordship will find that on the last occasion, your lordship says that whether they have applied for another thing, for transfer. I'm sorry, lordship. Next part from 4.3 in the report. They do not apply because admitted position petitioner is not our registered consumers. As per the provisions, consumer, they are not the registered consumer. There is no privity of contract between the petitioner and the authority. As of now, they do not apply for change of name in the name of Mathura or Jaiswal to any person of their legal years as per WBSCCL, as per regulation, that is the regulation 46. Now, lordship, I am drawing your lordship attention. What is the provision? My learned friend says that there is no such provisions. Kindly see the provisions. Regulation 46, page 16. Lordship got that? Now kindly come to page 17.
Page
17. Lordship got that? Connection to transfer of service. This is the heading starting. That is the clause 7. Now kindly come to 7.2. There are 3 parts. Suppose I have got the meter in my name. I want to change my meter in the name of some other person. I will give no objections. On that basis, the meter will be changed. And second part, if your lordship kindly come to 7.2b. Succession certificate or undertaking through affidavit, which I have shown on the last occasion, that is in specified form, as a legal heir of their original consumer and entitled to get such service meter as a in case of the demise of the original consumer. In case the number of legal heir is more than 1, the no objection certificate by other legal heir through affidavit in favor of applicant legal heir as per the format given in Annexure A3. Nothing has been done. Now, what is the application for a moment? Kindly see in their exception how they have given that. In their exception to this report, they have filed an applications only signature after downloading, because when they have given that form, there was no signature. Without signature, I will hand over the report also to my learned friend. And on that basis, in order to resolve the issue, we have given a letter to them. But this is the letter. Kindly see. Kindly see the letter. That is the enclosure 1. 22nd June, we have given this letter. What is the content of the letter? With reference to you above, this is to inform. On the last occasion, it has been fallen from your lordship whether you have intimated to them about this form. That this is to inform you that you have not applied for change of ownership as per prescribed format of WBSL till date, and you have failed to comply with the direction given on 22nd. The several occasions, this court was pleased to direct them to make an application in accordance with law. In several occasions, on 19th, 22nd, 9th, your lordship will find from the order itself.
My lady, only one
22nd,
illness.
9th.
I have not served with this report.
May I?
And nor it was filed in the court.
May I? I am just placing on the report, only the letter. 9th, and that's it is also stated you have just processed to online for the same bearing application without any supporting documents. We haven't said that you haven't given, just give us the supporting documents. That is the affidavit which is required as per the statutory provision. We will proceed to that. In this regard, you are requested to submit the application form in necessary as per the regulation 46, 7.1 and 7, which I have placed before your lordship. 7.2b for further course of action. Now, lordship, kindly see next page. It was booked on 23/6/2026. Now, kindly see the report given. In one hand, intimation delivered. Lordship got that? Unclaimed. Then again, door locked. Next page, lordship. Then it was further delivered to us. So what we will do, we are trying all level based, and kindly see when it has been delivered, kindly see the date. This is very interesting. On 7th of July, it was booked on 23rd. It was been kept hold by the post office for 14 days. So if a letter takes time to deliver them to the, now how we will get access to the meter board? We'll be embarrassed in all such situations. Now on another point, which my learned friend says, kindly come to page 6 of this report.
The application.
This is the application.
Not signed.
Not signed. And then we have given the affidavit format, how this is to be done, that has not been given. I have already next the order passed by your lordship on 28th of which has been made query by your lordship, 20th of March 2026. And against that appeal has been preferred on 31st. This order has not been set aside. And there was an observations under section 163, it can be done. Now, lordship, kindly see, which my learned friend is specifying whether a bill can be raised even after disconnection or not. Now, lordship, kindly come to regulation 55, page 10. Lordship got that? Now, kindly turn to next page 11 and drawing your lordship kind attention to clause 4.10. Lordship has got the vast because several locations in lordship. Now, if the meter is disconnected for 180 days, we cannot take out the meter unless he applied for transfer or something like that. Now, notwithstanding anything contained or elsewhere in any other regulation, the commission during disconnection period, this is the statute provide, for any reason whatsoever prior to termination of supply of agreement of deemed termination. Deemed termination takes place 180 days, lordship knows. The consumer is liable to pay the meter rent, minimum charges and fixed charges or demand charges as applicable. So on that pretext, after disconnection, this is the charges which has been placed as per these statutory provisions. It is not that we have charged them beyond the statute. So my humble submission before your lordship, before I part with my agreement, my argument, that three things it is necessary. She has sought for that there is an illegal disconnection. As per my submission is concerned, under section 163, notice has been given prior to that on 23rd of February. Subsequently, they have challenged this order. And this court was pleased to direct us to take necessary steps for disconnection. And on the pretext of that, we have made endeavor to make an inspection. Even this honorable court during the interim period, in the first writ petition, directed them to give access to the meter board. That has not been given. Against that, they have preferred an appeal. That appeal was dismissed. Then again, this writ petition, on that first writ petition, this honorable court was pleased to direct them to take steps, and under 163, you can take steps. And against that order, they preferred before the division bench. Division bench never entertained that, and already observation has been given They cannot reopen this at this issue. Already observation with that no, the disconnection is proper and you take steps in accordance with law. Now they have come before a lordship, and this court was pleased to direct us to make an inspection about the meter. And we have made an inspection. We have seen that the meter is in obsolete conditions, and we have already filed a report before lordship with a copy to them, and already specified that the meter cannot run in the name of a dead person. On this context, I have searched out one judgment where it has been specified by the Punjab and Haryana High Court. Kindly see, the meter cannot run in the name of a dead person. There is a dispute relating to the submersible pump. I just don't want to trouble your lordship much. If your lordship kindly see from page 3 onward, your lordship can page 3 onwards of the council, that since the partition suit is continuing from the last line, continuing the legal years of the deceased consumer, therefore the respondent cannot disconnect the electricity connection till conclusion of the partition proceeding also does not have any substance. Rather, the initiation of partition proceeding have only brought out one of the fact of the deceased consumer was having more than one legal heirs. This shows that petitioner is not only the legal heir of the original consumer. Therefore, even if the respondent board so desired, the said connection could not have been transferred in the name of a petitioner only. In case there is any objection from other legal heir of the deceased consumer, the petitioner could have got the said connection transferred exclusively in his name only if all other legal heir of the deceased consumer agreed to the fact, or there had been an appropriate adjudication for the right of the petitioner to get connection transferred in his name, and a decision on such adjudication would have been produced before the corporation. However, nothing of that kind has happened. On the contrary, the brother of the petitioner, who is the other legal heir of the deceased consumer, is a fierce battle with the petitioner over the right for property left behind the deceased consumer, including the connection in question. Therefore, by getting connection transferred exclusively in his name, the petitioner cannot permit it to unilaterally and collaterally damage the right of his 6 to 7 brother for the state and the belonging left behind to the consumer, who happened to be the father of the party. Moreover, so long as there is any objection any kind from any more of the legal heir, the respondent corporate is not supposed to transfer the connection in the name of either of them. Now, this is the very important which I am drawing on. Therefore, since the corporation cannot continue, lordship got that? Corporation cannot continue the connection in the name of a dead consumer. I am asserting on that. Therefore, only alternative left with the respondent corporation is to disconnect the electricity connection and to get out the picture of the dispute between the legal heirs. Till date, they haven't filed any affidavit before us. They haven't filed any succession certificate as per the statutory provisions. Repeatedly, this court has asked them to make an application, formal application in accordance with law, to make a transfer application, to make a transfer. But only lordship, it is clear, it transferred from the record itself that they have made only an application without signature. However, they have put signature here. We have already told them, and repeatedly I pray before, I just submit before lordship, that with a confidence from our officer, that let them go before the authority with the formal application with all relevant documents. We are agreeable to do that. But till date, nothing has been done. On that pretext, a meter cannot run in the name of a dead person since there is no privity of contract. And on that basis, my humble submission, this writ petition should stand dismissed with exemplary cause on the contest, because on several occasions, this court has directed to transfer, to make an application in a prescribed format. But they has flouted the order passed by this Honorable High Court, and on that basis, no one can sit over the right, and on that basis, this order has been passed, and on that basis, equitable relief, they cannot claim any relief from this Honorable High Court. This is my respectful submission before lordship.
May I respond, my lady?
I have also brought the original envelope also, if they dispute.
My lady, may I kindly respond? My lady, first, this report dated 15th July 2026 is neither in records nor served to me by any means.
Which one?
The report dated 15th July. He has now handed over to me. My lady, this report, they have filed 2 reports earlier and I have used exception. But if they are filing this report, I'm denying this report and I need to file exception to that also because I'm denying such facts. But my lady, this report has not been in the record and should not be taken into consideration at the time of hearing. They have to be given a copy to me on 15th July so that I could get ready with this report. But I have not seen this report earlier. My lady, so my first submission is this, that this report dated 15 July 2026 not served to me and neither on record, kindly should not be considered with. Second, my lady, kindly sees that my learned friend has not answered where is the prior notice prior to the disconnection. My lady, disconnection happened in 23rd March 2026 and he has shown intimation of May 2026. That is after your ladyship has passed an order for the inspection and not prior to that. My lady, till date, they could not show the 2 intimation. First, before 20th March 2026 that they are coming for the disconnection, 23rd March disconnection. So they could not say that on such and such date I could come. And on second, they have not shown any document or any notice, prior notice, to show that on such and such date I would disconnect because I went there, you have not allowed me inspection, so I would disconnect the line. But they have not given such. They have done it illegally. My lady, kindly sees what my learned friend has said about the notice dated 23rd February 2026, that is page 52. My lady, this notice is under challenge in the review. My lady, kindly sees the order dated 20th March 2026. It appears in the order itself that the grievance of the petitioner is directed against a notice dated 23rd February 2026. Read with the notice dated 27th February 2026. So these 2 notices are under challenge before the review court to check its veracity. Why, my lady, I'm saying this? Kindly sees one thing. My lady, the notice dated 23rd February 2026 appearing at page 52 kindly sees the first line, bill period January to March 2026, and the remarks is door locked. Right, my lady? Kindly sees, I have annexed this.
No, this is not under challenge before this in this writ petition.
No, my
Show,
lady, this
show.
is not under challenge.
Show.
But I have annexed the spot bill that is appearing at page 47. In this notice, they are saying that in 15 January 2026, so your door was locked so that we have done estimated reading, and estimated reading has to be done. And after that, my lady, kindly sees page number 47 of my writ petition. My lady sees this is spot bill. This is spot bill dated of 16 January 2026. For the month of January, they took the reading, gave me spot bill. And after this, my lady, they have sent another notice and said that you have not allowed access to me because I have sent a letter to them. My lady, kindly consider one thing. This notice is not independent one. I have given them 2 representations to rectify that bill because you came to my house, took the reading of the meter, gave me spot bill. That 104 rupees is there. But then you have issued another internet bill of the same month, January to March, and said that 8,000 bill has to be paid. My lady, but this notice is illegal and its veracity has to be checked by the review court and also by the consumer forum, appropriate trial court. My lady, that's why I'm telling this notice is not telling anything that they would come on 23rd March to disconnect my connection. This notice is under challenge before the review court, and without giving any prior notice, they came for inspection. They attacked the petitioner, entered inside, cut the trees over there, and after that, they went down after disconnection. But even before disconnection also, they have to serve at least 24-hour notice. So in both the notice, they could not show any one notice. The Act says, Section 163, you are asking for the inspection, you have to send two notice. First, for the inspection that I am coming on such and such date. But my lady kindly sees 23rd February notice. It says that within 1 week, you have to comply all.
Anything more you have to say?
And my lady, one more thing, kindly sees their report dated 22nd May 2026. My lady kindly sees the first page of the report of 20th May 2026. This report says, my lady kindly sees 4.1, meter number such and such, manufactured such and such, date 2002, guaranteed period such and such, reading on 20th May 2026 is such and such. My lady kindly sees the original consumer died in the year 1999. After that, they have changed the meter in the year 2002. That is manufactured in the year 2002. I could not take out another meter of the year 2002. After the death of the original consumer in 1999, they have disconnected. We went there. We said to change the name, but they have changed the meter. Manufactured in the year 2002. And they are saying they have expired in the year 2007. My lady, on what basis they are taking bills from me since 2007 to 2026 if I am not a consumer? And they have changed the meter in the 2002. One cannot take the benefit of his own wrong. He has done the wrong. He has given
By
the
supplying you electricity.
My lady, because I am also paying the electricity bills also. My lady, by not changing the name on my name, they have changed the meter in the year 2002. The original consumer died in the 1919. They did disconnection. After that, in the year 2002, they have changed the meter.
1999, consumer died?
Yes, 1999. And in 2002, they give a meter. My lady kindly sees, as per section 215 of the Electricity Act, I would also like to place. And not a single notice they could show that they are coming on such and such date. Because this notice, 23rd February.
What is there in 215?
My lady, this section 215 says that I am a consumer.
Section 215?
I'm sorry. Section 2, subsection 15. And as per section 9 of the Contract Act also, my lady, they have impliedly allowed me and took bill from me for 26 years. They are saying the meter has expired in 2007. On what basis they are taking bills from me? Huge bills, 8,000, 10,000 per month. And whenever I am saying that this bill is wrong,
What is the other section that you relied? 215 and what else?
Section 215 of the Electricity Act and section, my lady, section 163 of the Electricity Act.
163 is already there. What else?
What else? I'm telling you. And my lady, I would like to say that the notice dated 23rd February and 27th February is directly under challenge before the review court. In the writ petition number,
Can you challenge something new in review?
No, my lady. That's
Your
why
writ petition is dismissed.
Writ petition is dismissed, but review has been pending.
That doesn't mean your list is pending. Had it been an
number
appeal?
5357, I have annexed these two notices, 23rd February. And my lady, from this 23rd
Anything else?
My lady, one second. And my lady, one more thing. Regulation which they have shown, that is regulation WDRC 46 in their report. Kindly sees once. Nowhere in the law it provides that they would disconnect because I have not applied for the name change. That is after 26 years. My lady, kindly sees page. It's their report.
That you have submitted already. Anything new you want to submit?
My lady, connection through transfer of service meter in case of change of ownership or occupancy of any premises or purpose of supply. In case of ownership or occupancy, the purpose of supply where meter service is still continuing in the name of any previous owner. Yes, my lady, this section, this regulation does not provide for disconnection or does not bar any connection right now. And whatever the judgment he has submitted, I have not gone through this, but I am differentiating it on the facts because facts are different. There is a suit pending in that case, but in my case, I am the present user and I have applied. So I have submitted 3 documents, my lady. My voter identity card, my photograph, and my lady, one more thing, mutation certificate issued from the municipality. That also I have submitted to them. But their notice.
Nothing has been.
Why are you not taking a fresh connection? What is
Nothing
your problem?
My lady, they are doing illegalities. They are disconnecting.
Tell me what is your problem in applying for a new meter?
I have applied for. My lady, kindly sees guidelines. They have issued one guidelines. And they are saying that they will not accept the online application.
আজকে কি এটা জমা করলো exception? You filed the exception today? No.
No, exception has been filed on the last.
My lady, but they have filed another report today.
Submission. This report will not be taken into consideration.
I'm not placing. I am just specifying.
Consideration.
Report dated 15th July.
15th July. Will not be taken into consideration. All right?
Yes, ma'am.
Submission made on behalf of both the parties. Next Friday for orders. 24th for orders.
And I'm praying for urgent reconnection, my lady. Because the petitioner is a senior citizen. I would ready to comply with all the formalities, but
despite opportunities granted, you have not complied.
So, my lady.
Very well, you remain with your compliance. The authority will remain with their compliance.
I have made one online application. I have made one online application. I have submitted documents. But they are saying with this notice that you have not submitted any documents. That is wrong, my lady.
File another writ petition. ওটা থাকবে. File another writ petition. Each and every matter you will file a writ petition. You will go to consumer forum. Interim order, you go to the appeal court. You do this and you remain without electricity. This is what you choose.
My lady, because they have done the inspection. After this, they are saying that's why we went to the division bench.
Very well. Be happy. Yes.
I've got one assigned matter which has been hard for many days.
Yes.
Today was the date fixed for hearing of that matter that is appearing in the combined list. Let it be in the regular list on next Friday.
Combined list.
Yes, that's the problem.
And only submission of the written notes of argument.
Yes.
File it.
And my lord, only thing is to be distinguished the judgment of my lord Justice Divankar Datta.
You again want to distinguish?
No, my lord. Justice Divankar Datta has given 2 judgments. That is the Supreme Court. But that is to be taken into consideration by your lordships. But on that point only, I shall take note of your lordship argument matter. I shall argue.
Next Friday.
Next Friday at the top, my lord.
Matter in the supplementary list.
At the top, my lord. At the top.
Absolutely at the top.
I'll take only 5 minutes. Grateful.